that all submissions were moved to electronic submissions during COVID.
Do you know if any other witnesses would be able to answer that question?
Potentially Corey Smith, since I believe he was here during the COVID timeline.
Okay, I can reserve my question. Mr. Mullenberg kind of also, if I understand his question correct, I believe he was saying these sites have spills from prior operators. I guess my question to you is, when operators buy assets, wells, locations, etc., what is the responsibility of those spills? Do they transfer with purchases?
They do.
Okay. I believe that's all of my questions, Mr. Examiner.
Okay. Mr. Tremaine, any redirect?
No, I think we can cover everything else with Ms. Romero.
Okay, sounds good. So Ms. Hall, you're excused, but please stay available in case Mr. Tremaine needs you.
Thank you.
All right, thank you. Ms. Romero, I remind you that you're still under oath. Mr. Tremaine, go right ahead.
Thank you. Ms. Romero, when did you start with the Oil Conservation Division?
April of 2022.
Okay. And are you familiar, are you able to answer Mr. Garcia's question about guidance during the COVID period, or would we need to refer to someone else or some other record for that?
I was not here in that time, but I am aware that what Ms. Hall said was correct. There was no exemptions for spills and reporting, but we did move to a more digital format for COVID precaution reasons.
If there are any questions regarding the process of submitting C-141s or other documents related to incidents, would you refer back to Mr. Smith's testimony and exhibits?
I can probably answer some, but Corey would be the expert at that.
Okay. I'm gonna share my screen again and ask you some questions about the civil penalty calculator. So just to clarify, building off Ms. Hall's testimony, is it, and to clarify, this days in violation, when OCD calculates a violation, is like this column, the days in violation, is that the total number of days that OCD believes a violation occurred?
That is the total number, yes.
Okay. Is that the same thing, or is that different from the number of days that OCD may propose to calculate a civil penalty based on?
So in this circumstance, I did instruct Brittany to draft this on the total number of days penalized. However, the civil penalties themselves were not calculated until the 2024 date in which the last extension expired and we had still not received them. So from 2024 date till now, it received its cap, the max capacity for that particular violation. And so that, if even recalculated to date from the NOV, would still remain the same number. So I did not see it necessary to recalculate them again.
Okay. And specifically on this, you answered part of this, but the days penalized number here, if we amend this according to Ms. Hall's testimony, is it accurate to say that the entirety of those violation days penalized for violations occurred in 2024?
Yes.
Okay. I want to ask you about the major or minor release violations. We talked about this with Ms. Hall, and invite you to explain why OCD chose to propose a prohibited major or minor release violation for related to historic releases.
In this scenario, the options were to utilize this particular violation or to utilize a failure to remediate in an effort to be reasonable, and we selected a single day violation. If we would have opted for, failed to remediate, the would have been a multi-day violation and increased our civil penalty calculator. So OCD did so as a discretion authority.
Okay. Um, is there anything else that you wish to clarify or explain regarding this civil penalty calculator, which I have not asked you?
I don't believe so.
Okay. And we've kind of jumped ahead to shorten this, but you supervise both of the other witnesses in this case and their actions and work product related to this NOV and civil penalty calculator, correct?
Yes.
Okay. And you've heard that you are aware of the fact that both of these incidents have been open since 2016 and 2018, respectively, correct?
I'm aware.
Great. I mean, how would you characterize the amount of review and work that OCD that's necessary for OCD to put in reviewing filings in matters like this?
There's a significant time commitment involved in every submission. In cases like this, there have been, especially since the NOV was issued, multiple meetings and discussions on as far as providing technical assistance as to what OCD's Part 29 actually requires was provided to Buckeye in this scenario. And so we have spent a significant amount of time attempting to resolve this situation. And that would have been without any penalties had it been resolved prior to the NOV.
And would you agree with the statement that if the OCD is granted the order that we're requesting, or in the case of a potential settlement, it is likely that OCD will become responsible for completing the remediation of these two incidents and any others that are associated with Buckeye disposal?
I would agree with that.
And are you able to characterize the commitment or amount of work in terms of like financial or otherwise that would be associated with that remediation?
Aside from the financial, the civil penalty calculator probably does not encompass what we know would likely be the total cost of what these remediations would cost, just in sheer financial obligation, but that also would require OCD to continue to work as project managers to oversee that, and so significant employee costs as well.
And is it your expectation that the OCD would utilize either the reclamation fund or the BIL grant funds to complete the remediation?
Yes.
Given the clarifications that we've discussed on the particular civil penalties and what you've described as OCD's approach to the prohibited minor release violation and the history of these sites, is it yours and OCD's opinion that the cumulative proposed civil penalties are fair and reasonable?
I believe they are fair and reasonable. Should we have gone back and recalculate them, they would have increased.
Okay. And specifically on that, after OCD issued the notice of violation and required specific compliance actions, would Buckeye's failure to complete the required steps constitute an ongoing violation?
Yes.
And I believe this is what you just referred to, but is this, did OCD elect to update the civil penalty calculation after issuance of the NOV, or continue with the initial proposed civil penalty calculation?
We opted to continue with the initial proposed calculation.
Great. I think that takes care of all of my questions, Mr. Hearing Officer. I'd tender Ms. Romero for cross-examination.
Did Mr. Tremaine, before we do that, did Ms. Romero submit any written testimony?
No direct from Ms. Romero. No
Okay.
written direct.
Were there any exhibits that came in through her?
Actually, there's only her resume, and then let me just double check everything 8 through 25. That's not correct. 24. Ms. Romero is the provides the authentication for Exhibit 25. That was the October 2025 email with where OCD outlined a final set of deadlines that Buckeye needed to comply with, which predicated our informal discussions in December, where after which we were operating under the belief that Buckeye was not able to complete the remediation steps outlined in that email. So that's her email. And the remainder of those exhibits 26 through 28 are attached to Mr. Smith. So just exhibit 5 and exhibit 25.
Do you want to ask this witness if she adopts under oath her exhibits and if there are any changes?
Sure. I think she didn't do direct, so there's I thought they were admitted, but yeah, Ms. Romero, are there any necessary corrections to either your resume or the Exhibit 25 email to Buckeye?
Fair enough.
Perfect. All right,
Thank you.
Mr. Molenberg.
Thank you, Mr. Hearing Officer. I have no questions for this witness, and I guess that's that.
Mr. Garcia?
No questions of the witness, but potentially counsel.
Sounds good. And then, Mr. Garcia, did you have a question for Mr. Corey Smith?
I did earlier, and I think Rosa alluded to it in the beginning of her testimony. I guess I can clarify for the record. Ms. Romero, I had asked Ms. Hall about basically the division's policy or stance on spills and how that occurred during COVID. Do you know how that was affected?
Timelines were not changed. However, we did move to a digital format.
So if a spill occurred prior or during COVID, it just followed as the rule said, other than the submittal process?
Yes.
That's all my questions, Mr. Examiner.
All right. So then we don't need to recall Mr. Smith?
No.
Okay, very good. Okay, is there any redirect, Mr. Tremaine?
Only one question, Ms. Romero. I certainly understand the questions about the COVID period, but I just want to put a nail in this. Is OCD proposing any civil penalties for violations that would have occurred during or shortly after the COVID pandemic period?
No, the proposed civil penalties are all from the 2024 date, the last extension.
Okay. Nothing further.
All right. Let me see if I have any questions. Hold on one moment. Mr. Tremaine, would you please bring up the exhibit that shows the penalty days calculation?
Yes, this is OCD exhibit number. Let me get it right because they're different in the two. 9.
All right, let me see if I can make this bigger because these numbers are so small, it's hard for me to, there we go. In column number, well, I don't know what column number it is, but in the one with the heading that says days in violation, rows 2 and 3 and further down say 2,250. Is that correct?
No. Brittany did bring this up. Ms. Hall brought this up when she spoke. That was the total days they were in violation. The correction did need to be made under days penalized, that it should be 252 days instead of the 2,000 some odd days that are there. Sorry, I can't read it either. However, should we make that correction, it makes no changes in the total amount.
Right. So Mr. Tremaine, can this exhibit be amended to fix that?
Yes, it may. I believe we actually already have that completed, but we caught those 2,250 days even though that wasn't OCD intent, we caught that after the preparation of the pre-hearing statement. If it's helpful, a brief proffer. All of the fields in green here are manual text entries. The blue are drop downs that automatically change the content that displays in the beige. And then the orange is the one. So what we put here is this changes the calculator, whereas what's put here in this column in the green does not change the calculation. So the legal argument here is that the same requirement existed reinstatement of OCD's civil penalty authority, and this was carried over because basically any reasonable number we put in there resulted in the same result. But this we should have caught that and corrected it. I didn't catch it before. So we're happy to provide that update.
Okay, Mr. Molenberg, your position?
I'm fine if the division would like to update the exhibit.
Okay. All right, Mr. Molenberg, the state has presented its three witnesses. Do you, and you said you don't have witnesses, so you don't have a case in chief, is that right?
That's correct.
All right, do you have a rebuttal case?
No, we do not.
All right. Mr. Tremaine, do you rest your case in chief?
Yes, we do.
Okay. How do the parties want to proceed from here? It sounds like Mr. Molenberg wants to continue negotiations. Is that right, Mr. Molenberg?
Yes, I would like to have some discussions. I would imagine you would take this matter under advisement, and we can let you know if we succeed with anything. I don't know what the time frame would be for a decision, but I can discuss that with Mr. Tremaine.
All right. Well, Mr. Molenberg, you're well aware that the standard of evidence is preponderance, and that, I can only consider relevant and reliable evidence in the order. Mr. Tremaine, how do you want to proceed?
I think that if Mr. Molenberg wants to talk, I think we could set this for a status with the other case on March 12th. If Mr. Molenberg's available as a placeholder, I suspect we will. To be candid, OCD has very limited options in how to settle a case in this posture. The other matter that was continued from today is in a very similar posture. That operator was able to, we believe, meet our terms. So I believe I will know very quickly if settlement's possible. And then we could come back on a status on the 12th and issue my prayer for relief if we're unable to settle.
So as Mr. Tremaine said, it's going to be
Mr. Examiner, what you think on that? Could I ask counsel one question?
yes, go ahead.
Mr. Tremaine, one question I have for you, and I think you're the right one to address it, is in your application, your opening statement seemed to hint at certain requests that you were seeking for the division in an order. I don't know if I saw in the exhibits like a bullet pointed list of this is what we seek in an order. Is that something you could provide to us of like civil penalty blank, XYZ? Because I believe you hinted at some orphan statuses, which caught me off guard a little.
Yeah, that's a good question, Mr. Garcia. So this one was one where we had every reasonable belief that Buckeye was not able to complete the remediation activities under Part 29. But that wasn't formally documented, so we did not amend the notice of violation. In terms of the sanctions, we're asking for the sanctions as proposed in the NOV, but I'm happy to provide a bulleted list of those along with the updated civil penalty calculator. The only change is that because we've become formally aware that Buckeye does not have the ability to complete the remediation, these sites are going to inevitably fall on OCD to remediate. So we have covered that to some extent with Ms. Ramiro, but I think based on the Buckeye's filings, the record is clear that OCD is going to have to do that. So on that basis, that admission alone, OCD believes that the remedy of authorizing OCD to complete plugging and remediation is appropriate under the circumstances. Buckeye has implicitly acknowledged that the incidents and any associated facilities will be, if they don't have the ability to complete the remediation, they're not going to have the ability to complete the remediation and complete any plugging and abandonment activities. So I think the record is clear that that remedy is appropriate. That's the only thing that we've changed from the NOV in the pre-hearing statement or our presentation today. Did that answer your question?
Yes, it did, and I would take you up on getting a bullet point list. It makes things easier with the number of cases we hear on a daily basis. To when we come back to it, we know what's being sought after.
If we get to that point, I'm more than happy to provide both that list along with the revised civil penalty calculator and a proposed order.
Yeah, and that request is dependent on Mr. Examiner's decision, I guess, on your status conference possibility. But I defer to him.
Okay, so Mr. Tremaine, Mr. Molenberg, it sounds like giving you 2 more weeks is more than enough time to figure out whether you're going to make some dent in this civil penalty calculator or not. And at that time, Mr. Tremaine, if whatever happens, if it's a settlement agreement, please let me know. Otherwise, if it's an order that is required, then let's discuss who's going to draft it. All right. Anything further on this case, Mr. Molenberg?
Nothing further. Thank you,
All right.
Mr. Herringhouse.
All right. Thank you, sir. Anything further, Mr. Tremaine?
Nothing further.
We're off the record in this case. That leaves us with one case today, and this is Longfellow Energy 25804. Entries of appearance, please.
Good morning, Mr. Examiners. Sharon Shaheen on behalf of Longfellow Energy.
Good morning.
And
Good
good
morning.
morning, Jackie McLean on behalf of XTO.
Good morning, Ms. McLean. What I thought we could do is, there's a little time before lunch, and what I thought we could do is at least just get some of the housekeeping out of the way before we take a break for lunch. However long the parties want, we're virtual. It's really, I don't know how much time the parties want. I could have as little as 15 minutes, but I also have Mr. Garcia to think about as well. But let's try to get some of the foundational stuff out of the way. Now, parties have submitted, thank you, Mr. Garcia. The parties have submitted exhibits, pre-hearing statements. I've reviewed those. I think I know what the issues are here, and I'll go over that with the parties in a minute to make sure that we're all on the same page. There have been some rebuttal exhibits submitted as well. I'm not sure, Ms. McLean, if you've seen, there have been several, it looks like several rebuttal. So I'm a little confused, Ms. Shaheen. Hopefully you'll help me out here. Okay. So I see here, let's start with the basics here. For XTO, Ms. McLean, I see one filing on the 20th it has 34 pages. Are these all of your exhibits?
We have that, and then we filed rebuttal exhibits on the 25th.
I wonder why I don't see those. Hold on a second. You said the
They're-
25th?
Yes, they're posted. It's the second to last document
I see it.
in the
I see
case
it.
file.
I wasn't sure which party this was for. It didn't say on the cover page. I couldn't tell whose it was, but now I understand it's XTO's.
Yes.
Okay, very good. So this is a 6-page document.
This one is, yes, 6 pages.
All right, fantastic. So I have a 34-page document and a 6-page document. Let's begin by asking Ms. Shaheen. Ms. Shaheen, have you had a chance to review these 2 submissions?
Yes, I have.
Excellent.
And the
What is
only
your position?
Yes, the only exhibits we object to, and I'm looking for my notes here to make sure I get it right, are rebuttal exhibit A8 and rebuttal exhibit B7. Those are
Let me
the
see if I
only,
heard you. Let me see if I heard you correctly. You said A as in apple 8 and B as in boy 7.
yes, I believe that's correct.
You're objecting to those 2.
Yes,
Okay, fantastic. So then all the other exhibits can come in through stipulation.
that is correct.
Good. I wanted to make sure I understood you. Okay. So Ms. McLean, did you catch that?
I did. They're A8 and B7.
Exactly. Okay. So for the court reporter, let me just be very clear. Longfellow has stipulated to XTO Holdings exhibits A1 through A7, B1 through B4, and then the rebuttal exhibits B5 and B6. There is an objection to A8 and B7 at this time, and we'll deal with that when we get there. Let's go to Longfellow. Now I want to make sure I'm looking at the right the right documents. So Ms. Shaheen, I think the foundational document came in on the 20th. It's 136 pages.
Yes,
All right, fantastic. Let me just start with that document. Ms. McLean, have you reviewed these exhibits?
Yes, I have. And
Fantastic.
no objections to their initial exhibit packet.
Very good. So let me just be very clear. So we have exhibits. I think we have tabs. Okay. So we have a compulsory pooling checklist, tab 1. We have an application, tab 2. Then we have under tab 3, exhibit A1 through A7, B as in boy, B1 through B6, C1 through C8, and D1 through D5. And there's no objection to any of those exhibits.
No objection.
Fantastic. Thank you. They're admitted into evidence. Okay, now I have another document here. This was submitted on the 24th. It's 32 pages. Oh, these are rebuttal exhibits. Okay. This is rebuttal exhibit 1, and it looks like emails. Is that what this is, Machine?
yes, it is.
All right, very
These are
good.
the emails from 2025 between the parties. I believe
Okay.
XTO offered as a direct exhibit emails from 2026 between the parties, and we're just supplementing the communications with the 2025 emails.
Okay, so this is rebuttal exhibit 1 for Longfellow. Miss McLean, your position?
We object to rebuttal exhibit number 1.
Okay, let me write this down. Rebuttal. I don't care why right now. The point is that you just are objecting. All right. So that's not going anywhere right now. Then we also have here, I think, okay, these are yours. We have a 2-page exhibit. It looks like it's rebuttal exhibit 2. And your position on Longfellow rebuttal exhibit 2, Ms. McLean.
No objection on rebuttal exhibit 2.
Very good. So that exhibit comes into evidence. Am I missing anything, Ms. Shaheen?
No, that's it.
All right, very good. All right. So we've dealt with the exhibits through stipulation. There are 3 that are not coming in at this time. Which party wants to go first?
I was assuming we would go first because we have the only application.
Okay. That's a good assumption, but I don't want to tie anyone's hands at this point. Ms. McLean, you okay with that?
Yes, that was what I was thinking would
Okay.
happen as well.
All right, perfect. Let me just go over my review of the exhibits and what I think are the real issues here. I did have a conversation with Mr. Garcia this morning about this case, but I've had some time to look through the exhibits. If I'm wrong about these issues, you can tell me afterward, but I'm just going to tell you what I see, and maybe that'll help. Maybe that'll help focus us on what's going on here. Number 1, I see the first issue here is the prudence and the efficiency of the development plan, and the only plan we have is Longfellow's. So that's what I mean when I say that. It looks like there's a technical dispute about how best to develop this 320-acre spacing unit in the Yezo formation. It looks like Longfellow's position is that it proposes a full horizontal development plan consisting of 8 one-mile wells. Longfellow argues that it's the most efficient way to drain the reservoir, estimating a 14.9% recovery factor compared to 4.9% for vertical wells. XTO's position is a little different. They contend that 8 wells per half section is overly dense and not warranted for this specific area. They argue for extended laterals, 1.5 miles or more, across adjacent sections 32, 33, and 34 to reduce surface locations and increase capital efficiency. So that's the first main issue I see here. Do the parties agree with what I've said so far?
I'll go first. I agree that those are issues, but I believe that there are a number of other issues that are important here.
Right. I'm only going one issue at a time. So I agree with you. There are more issues. But but my characterization, my summation of that one issue, do you take offense to any of that?
No, I think you've accurately captured some of the arguments of the parties.
Okay. And Ms. McLean?
I agree with Ms. Shaheen.
All right, thank you. All right, let's go to the second issue I see is the reasonableness of the estimated well costs. There's a significant disagreement here over the financial requirements to participate in this project. I see Longfellow's position as the AFE estimated costs at approximately 6.1 million per well for pad development and 7.57 million for the initial single well phase. They argue that costs reflect their high fluid loading simulation strategy, which they claim yields superior production results. XTO's position states that Longfellow's costs are not fair or reasonable, and they're significantly higher per foot of lateral length than other operators in the Yezo. XTO also points to a 22% cost overrun on Longfellow's recent Aussie project as evidence of capital inefficiency. Ms. McLean, does that accurately outline the reasonableness of the estimated well cost?
Yes, I believe so. I think that's a good summation of what our argument is. And then we'll, intend to present more as well.
Right. This was just this analysis that I conducted was really just for me and Mr. Garcia to help orient ourselves to the real main issues here, because this is one of the problems with these contested cases is we don't meet beforehand and sort of outline what are the issues here. So it's up to us to figure it out from the exhibits, which puts us at a disadvantage. Ms. Shaheen, did I accurately capture a summary of your estimated well cost issue?
I believe so. We will,
Good.
of course, offer additional evidence.
Of course you will. Okay, I have I have three more issues that I spot. Maybe there are more, but this is what I spot. The lease expiration and imminent risk. It looks like there's a July 1st termination deadline for the underlying federal leases. Longfellow's position, because of the current shallow unit operator, Acacia, is in bankruptcy and production has ceased. They must drill immediately to hold the leases for all parties. XTO claims Longfellow has no active rigs in New Mexico and is unlikely to establish production by the deadline anyway. XTO suggests they could preserve the lease via their own vertical well or by coordinating with another operator such as Mac Energy to penetrate the leasehold. Is that fair? Okay.
You read
No.
all of our exhibits very, very well.
I had time during the status conferences and I came in early this morning, so I wanted to be prepared. Number 4, preservation of waste and protection of correlative rights. Both parties invoke these regulatory mandates to support opposing outcomes. Waste. Longfellow argues that vertical development would leave millions of barrels of oil in the ground and cause a 533% increase in surface disturbance. XTO argues Longfellow's plan involves monetary waste due to unproductive lateral length and unnecessary well density. Environmental constraints. Longfellow provides evidence that Section 33 contains desert sagebrush lizard habitat, making vertical drilling on XTO's acreage environmental challenging, whereas their horizontal plan avoids these areas. Finally, we have our good faith negotiations, which always is an area for lots of extraneous evidence. But it's a factor, so we entertain it. Good faith negotiations and title status. Negotiations. XTO alleges that Longfellow has not engaged in good faith, claiming Longfellow threatened to let XTO's lease expire unless XTO agreed to term assignment of an unrelated lease. Longfellow denies this, outlining multiple deal structures offered over 5 months. And then we finally have the title status. Longfellow taking evidence to show XTO's record title position is currently incomplete and in flux, which they argue undermines XTO's claim that it's ready to independently develop the acreage. So, those are the issues that I spot. Are there any other major issues that I have missed?
I'm looking at my notes real quickly here.
I think from XTO's perspective, you've hit pretty much all the high notes.
Okay, thank you.
I agree. I mean, there's 7 factors and you identified 6 of them. So, I mean, we'll address the 7th factor as well. And I think that probably relates to geology. So we'll just offer our evidence and we'll see whether you have any, whether you believe that's an issue here.
Perfect. All right. So, Miss Shaheen, since you're going first, I'm not sure we need an opening statement here because I just sort of went through the positions of the parties as I saw it, and both of you have agreed it's a good generalized statement issue by issue. How many witnesses do you have?
Longfellow has 3 witnesses.
All right. Would you call all 3, please?
Yes, Ms. English, Mr. DeHammer, and Mr. Mitchell.
I can't see. Hold on a second. I got the screen in front of me and I can't see. Aha. Okay. So I heard Miss English. I didn't hear the other 2 names.
Jacob DeHammer
DeHammer. Thank you.
and David Mitchell. And all 3 have previously testified before the division.
Perfect. And I'll ask that question after we get them sworn in. I see you, Mr. DeHammer. All right. I see Miss English and I see Mr. Mitchell. That's great. Okay. Would you all 3 raise your right hands, please? Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Now, one at a time, and I'll start with you, Miss English. Would you please spell your name?
Yes, sir. Rebecca, Rebecca, English, English.
And Ms. Shaheen advises me that you've been previously qualified as an expert by this division.
Yes, sir.
Would you tell me in what capacity?
Sure. It's been many, many years. I think it was it would be 2016 and 2017 is when I was previously qualified in the capacity of landman.
Landman. Well, if you were qualified back then, you're even more qualified now, so I don't have any reason to doubt that. Mr. DeHammer, would you go next?
Yes. Can you hear me?
I can.
Perfect. You want me to spell my name?
I do.
Jacobdehamer.
Thank you. And the previously qualified expertise, what is the field?
Petroleum geology.
Perfect. How long ago was it?
Like 6 to 8 months ago.
Oh,
My first
okay.
hearing. Recent.
With me? Did we have a hearing together?
Just a pooling order. Yeah.
Oh, okay. Oh, was it a hearing by
Luckily,
affidavit?
yes.
Okay, and I qualified you at that time.
Yes, sir.
Perfect. All right. And Mr. Mitchell, would you spell your name?
DAVIDMITCHELL.
And the area of expertise?
Petroleum engineering.
And when were you qualified for that?
It was probably 4 or 5 years ago at another contested hearing.
Hmm.
Did that not come through?
I won't be able to capture what you're saying. Plus, you're frozen.
I'm sorry. Can you hear me now?
Actually,
Sad.
Mr. Commissioner, you're frozen. Sorry.
And I'm frozen. All right. Hold on a minute.
Gregory, I think
I
it's yours.
turned my
I can
camera
see
off
them all.
because it seems. I'm sorry.
I was gonna say, I believe it's your side. I can see
Can
all
you
the
hear me
witnesses.
now?
We can.
Okay. My camera off because my computer said it was overheating, which it's a brand new computer, so that's unfortunate. Mr. Mitchell, I had asked you when you were qualified by this division as a petroleum engineer.
Approximately 5 years ago, during a separate protested hearing.
Okay, perfect. Thank you, sir. What is a petroleum engineer?
Petroleum engineer is an engineer that's responsible for the drilling, completions, and production of subsurface reservoirs, as well as the surface equipment and infrastructure required to produce them.
I see. Okay, perfect. Thank you. All right. Now it is noon, basically, here in Mountain Time, and I wonder if the parties would like a break to get something to eat before we begin in earnest. Ms. Shaheen?
I think that would be a good idea, particularly for you and the technical examiner, and for Ms. McLean as well.
Mhm. Okay, well, that's very kind of you. So I was thinking about a half an hour. Is that okay with you?
That works for me.
It works for me and Mr. Garcia as well. I say that because this hearing may go into tomorrow. I don't know, but I figure if we cut down the lunch, maybe it won't. I don't know.
Good idea.
All right, sounds good. Miss McLean, does that work for you?
That works for me.
All right, and my computer needs a rest, obviously. So, okay, we're going to come back on the record at 12:30, which is in about 33 minutes from now. And Mr. Court Reporter, I hope that's okay with you.
That's fine by me. Thank you.
All right. So thank you, everyone. We'll be back on the record. We're in recess now.
Thank you.
Thank you.
It is 12:30 on the nose, and we are back on the record. Ms. Shaheen, are you ready to proceed?
I am.
Which of your witnesses do you want to call first?
The landman, Ms. English. And
Okay.
I would just note, I'm hoping that we can get Mr. DeHammer to testify today as well. So if we start running too long with Ms. English, maybe we could hop to Mr. DeHammer because he's not available tomorrow.
Okay, that sounds fine. I can't imagine Ms. McLean would object to that. So go right ahead,
And
Ms. Shaheen.
I'll just let you guys know, we are not planning to cross Mr. DeHammer, the geologist.
Ah, okay. Thank you. Go right ahead. Ms. English, I remind you, you're under oath.
Yes,
Good
sir.
afternoon, Ms. English. Let's start by describing the acreage that Longfellow seeks to pool in this proceeding.
Sure, excuse me, sorry. Yes, we are looking to pool the south half of section 33, township 16 south, range 31 east.
And when did Longfellow acquire its interest in this acreage?
I believe it was before my time at Longfellow, but I believe it was in 2024, 2023 timeframe.
And what tracts does Longfellow have an interest in?
Sure, yeah. Let me pull up my map, just make sure I'm not misspeaking. Longfellow has an interest in the south half, in particular, in the east half of the southwest quarter and the east half of the southeast quarter.
And I'll share now if everyone is patient with me for a sec. Can everyone see what I'm trying
Yes,
to
ma'am.
show, the direct exhibits? Let's turn to your exhibit A7 quickly here because I think it'll be helpful to talk about the interest in the tracks.
Sure.
Is this your exhibit A7?
It is.
And so can you describe using the colors here in this map what Longfellow's acreage is in the south half of section 33?
Yes. Yeah, and I'll take just a quick step back because this map does have quite a bit to it. This map shows Longfellow's interest across what we dub the Cedar Lake area. And the interest is all contained within the black outline, which is the North Square Lake unit boundary, which is part of what's at issue here today. And Longfellow's interest is the yellow. So you can see that we have leases across many different sections and many different proposed units. Our proposed units are outlined in red. The unit in issue is the south half of 33, where you can see our interest in the east half of the southwest and the east half of the southeast, all under the same lease. So all of Longfellow's interest in section 33 is under one federal lease. The blue is XGO's acreage. So we show XGO's acreage across, again, kind of similarly, the Cedar Lake area so that we can appropriately depict the correct amount of leases that are potentially expiring in July. The difference between the darker blue and the light blue, I don't know if everybody can like make out the two distinct colors there, but the lighter blue are definitively record title shows XTO with 100% interest. The darker blue has a little bit of nuance to it, and I don't know if we want to talk about it now or later, but we show each of them separate so that you can kind of see what we're dealing with.
And
can I ask a question real quick? Just in the interest of time, we haven't objected to her direct testimony or any of their direct testimonies or exhibits. And I thought like all the other contested hearings that they would adopt their testimony, then introduce rebuttal exhibits, and then we could cross. Are we going to go through all of her testimony, or what are I guess if we could just kind of outline the order of operations, that would be helpful.
Ms. Shaheen?
Yes, I was just hoping to have Ms. English summarize her testimony. And I think it's helpful to have a graphic representation of what her testimony is here. And of course, Mr. Examiners, if I'm taking too long or Ms. English is taking too long, just let us know and we'll move it a little faster.
What if we do this? What if we do this? How many eggs? I don't have the exhibit packet in front of me because my computer is having trouble. How many exhibits came in through Miss English?
I believe there are 7 direct exhibits, and then rebuttal exhibit A8 is also an exhibit that's sponsored by Ms. English.
Okay, all right. And the 7 exhibits, is there a way, they are in evidence, and Mr. Garcia and I have reviewed them. Is there a way to do sort of a broad summary of Miss English's expert opinion, maybe let's say 10, 15 minutes, and then we can see if she needs more time after that?
That sounds good. I was hoping to get her through it in about that much time.
Sounds good. So Miss McLean, I know you didn't object, but you wanted some operational guidance. I think what we'll do is we'll give each witness a 15-minute period to summarize their self-affirmed statement, if there is one, and their exhibits, and then we'll open them up for cross-examination. So please proceed, Ms. Shaheen.
May I just clarify one thing? Because
Yes.
I was thinking that 10 to 15 minutes would be the direct, and then there
Right.
would be, we would offer what rebuttal we can now,
Mm-hmm.
and then there would be cross. But if you want to do it differently, I'm happy with that as well.
As we've done it in the past, if rebuttal exhibits have been submitted and reviewed by opposing counsel, then that witness should incorporate their rebuttal testimony during their 15-minute summary. Now, of course, Miss English's A8 is not in evidence, so you might want to spend a little time at the end trying to lay a foundation for A8.
Just for clarification for the record, the rebuttal exhibit A8 is actually XTO's rebuttal exhibit, and
I'm
Longfellow
sorry.
calls theirs rebuttal exhibit 1 and rebuttal exhibit 2.
Thank you for the clarification.
Yes.
Agreed.
And so we also have, rebuttal testimony in response to their written testimony, and we'll try to weave that in as we go along.
Yeah, it's up to you. And if you need more time, just ask for it. I'll just start the 15 minutes now.
Okay. So turning back to exhibit A7, we were discussing that the light blue and the dark blue represent XTO's interest. Is that right, Ms. English?
Yes, ma'am.
And do you know when XTO acquired its interest in these blue?
Sure, yeah. Don't quote me on the exact year, but I believe XTO's had this interest for some time, several decades, 60s potentially.
Okay, and then the difference between the two, the light blue and the dark blue, there's some discussion in your testimony about a reassignment.
Yes, ma'am.
Okay, can you talk about that reassignment and the status of the reassignment?
Sure, yeah. At some point in time through, various decades, I can't eloquently speak on the exact date, but XTO, I believe, issued a term assignment. And again, none of this is disputed. We all agree on this, but XTO issued a term assignment to a few parties. I believe it was in a third, so 3 separate parties. And forgive me if I misquote this. I'm sure XTO will clear this up. The term assignment termed out several years ago in around 2006, so about 20 years ago. And in that term that occurred, the parties, XTO was due a reassignment from the parties. There's no question. We don't dispute that at all, that XTO does indeed, they are owed a reassignment. From what we can tell, the reassignment did not occur from the 3 parties. I think there is some dispute on who the 3 parties are, but we know that one of them was Occidental, and then the other 2 are, our title shows it as one part, as potentially different from what XTO's title is, but that again is not an issue. So I believe XTO sought a reassignment from Occidental back in 2006, and Occidental did give XTO a reassignment, thereby XTO having record title again in 1/3 of those 2 darker blue tracks. That assignment was not recorded. And so we were not aware of that assignment until we, spoke with XTO recently, and they, we pointed it out and they knew about it, and they then subsequently recorded that. So that is good. It's of record. The other 2/3, I think XTO is seeking those reassignments. I have inquired with my counterpart at XTO, and I don't believe that they've gotten them yet, but that they are seeking them. So what that means in terms of title is that in the 2 darker blue tracks, we do not dispute that XTO is owed a reassignment, but we do not believe that they have record title at this time.
Going back to the map A7, you mentioned something about other Longfellow developments in the area. How many other additional developments does Longfellow have in the area?
Yes. So it's kind of a moving target because, we're in this hearing at this time, but you can see the red outline on these units. So Longfellow right now has several different units that we are actively working to get drilled before this July deadline. And if I need to, I don't know if anybody has questions, but I can explain why the deadline is in July. If that's not an issue, we don't have to do that. But presumably all of the leases, including Longfellow's yellow leases, with the exception of section 32, is the only exception, have an expiration of July. And this includes all of XTO's leases as well.
And are you aware? Oh, I'm sorry.
No, go ahead.
Are you aware of any developments that XTO has proposed in this acreage that's depicted within what you've deemed the Cedar Lake unit?
No, ma'am.
Now, your exhibit A5 is the usual chronology of contacts. Let's scroll back to that here. And of course, the important part is the chronology of contacts with XTO here. And I'll make it a little bit bigger. So does this represent the timing of the contacts that you've had with XTO throughout the time, since the time you first proposed the well on August 5th of 2025?
It does, with the exception of one thing, that this ended, we submitted these last week, and even since last week, we've had numerous conversations with XTO that are not depicted on this chronology.
And in your statement at paragraphs 27 to 40, you actually detailed all of these conversations, communications with Exxon. And could you just hit the high points of your paragraphs 27 through 40? And
Yes,
I'll turn to that now. That's PDF page 21.
Sure, yeah, and I can keep it somewhat brief. So I think the high points are we contacted XTO back in August through October of last year to talk about a standard protocol, which would be to offer a term assignment to XTO or a participation through an operating agreement in this specific unit, the south half of section 33. This conversation took place before Longfellow or XTO were aware of any issues with the Acacia bankruptcy proceedings and the Acacia shallow unit that holds these leases. The original term assignment was to offer to take a term assignment in section 33 as well as section 1 in a different township. So we submitted a single term assignment that had 2 different tracks involved. One is in the south half of 33 and one is in a different township in 18 South 28 East. Or excuse me, I apologize, 18 South 27 East. That conversation, we submitted it, they were grateful for that, and they said, we'll look into it. shortly after, Longfellow discovers that we have quite a big problem with this Acacia bankruptcy issue. So I call XGO to let them know that this has come up and that Longfellow's, were you aware of it? And Longfellow's doing everything we can to try to sort through the nuances of this, and we'll get back in touch later. So then fast forward to, I'll skip quite a bit, multiple conversations took place, and we believe we've come up with a solution that can benefit both Longfellow and XTO, which is as simple as I can say, expedite putting wells in the ground so that we hold both our lease and XTO's lease. We discussed that we can come up with a deal structure, whether again that's term assignment, proposed JOA, or anything, and agree that no problem, we'll get there. Fast forward to 2026, we have in-person meeting. We speak to them often, and we offer everything from the original term assignment, which involved another tract in another area, to assign us 100% of the interest, we'll hold your wells, we'll hold the rest of your lease for you, to we'll give you every option through operating agreement, participation, term assignment, anything that you would like. You just tell us what you would like to do. Our point being, we just need to get wells in the ground. And we still are discussing even today, but unfortunately we have not come up with a plan at this time. So the summary is just several months of communications, climaxing obviously into today's hearing.
And with respect to paragraphs 45 through 50, here you talk about XTO's actions and inactions. Has XTO at any time, to your knowledge, until yesterday at about 1:30, proposed any alternative development that would include Longfellow's lease?
Not that would include Longfellow's lease. No, ma'am.
And I think we've discussed before the urgency of development. That's in your paragraphs 51 through 57. Is there anything in particular you would like to highlight with respect to that urgency?
And I apologize, I'm shuffling to get there. I think I think it's undisputed about and perhaps it's not, but undisputed about how we got here with this Acacia bankruptcy. But our take is, my summary is that it's absolutely paramount that both parties get their leases held. We have communicated, and to be clear, Longfellow has communicated often with the BLM on this, because we've taken the lead in communicating and then providing those communications to the other third parties that we're working with in this area. So XGO is not the only third party that we have discussed this situation with. If you go back to the map, Ms. Shaheen, you can see we don't have other, and it's not necessary, but there's not other parties listed on the map, but there's third parties who have leases in those white spaces. And we're in the same conversations that we've been in with XGO on those tracks as well. So the whole thought process is, let us take the lead, let us get this administratively approved, and let us drill to hold everybody's leases, all within the time frame that the BLM has told us is required, which is before July of 2026.
Turning now to XTO's exhibits, have you reviewed the exhibits of Ms. McKee?
Yes, ma'am.
And here, let me scroll back to that. That's at PDF page 3 of XTO's direct exhibits.
Yes, ma'am.
Oh, page 2. Here we go. And so with respect to paragraph 6, I'll scroll down here. Have you reviewed this testimony of Ms. McKee's regarding XTO's ownership of 100% of the federal lease?
Yes, ma'am.
And as you discussed earlier, they do not have record title to 100% of that. Is that correct?
I do not believe they do. I have spoken with Miss McKee and asked the question, and the response is that they are working on getting record title.
And here in paragraph 8, where Ms. McKee represents that the acreage was all reassigned to XTO on November 1st of 2010, is that a true statement?
I don't believe it is. I believe there's outstanding reassignments that still need to occur.
With respect to paragraphs 15 through 20, here Ms. McKee discusses a number of communications in her paragraphs 15 through 20. Have you reviewed her testimony here?
Yes, ma'am.
And in particular, well, let's start with paragraph 15. And 16, where Ms. McKee represents that Longfellow never responded to XTO's inquiry about removing XTO from the force pooling. Can you talk a little bit about that from Longfellow's perspective?
Sure, yeah. I think, and perhaps I can get clarification, but I'm not sure what the request was. We never responded. My understanding is that we've been in contact with XDO, and every question slash email slash phone call has received a response very immediately. So if I could just understand a little bit more as to exactly what that is and perhaps look at that, then maybe I could opine on that a little bit more. But my understanding is that we've always been in contact and responded.
Okay, sounds like you might need to come back after Ms. McKee's testimony. With respect to paragraph 17, Ms. McKee makes a number of representations here about Longfellow, the first being Longfellow having no plan to develop the Van Halen spacing unit with XTO. What is your response to that?
That we were in person with XTO clearly with the intent that we would like to strike a deal in order to develop the Van Halen spacing unit with XTO. I'm not quite sure. We wouldn't have approached them to attempt to get an operating agreement, a term assignment, an assignment, if we had no intention of doing this.
And there's a number of statements here about LFE or Longfellow drilling a vertical well. How did that come up, and what is Longfellow's position with respect to drilling the horizontal wells?
Sure, yeah. It is absolutely not disputed that discussing drilling a vertical well occurred in our in-person meeting. Our conversation in the in-person meeting was, hey guys, we've previously given you a term assignment on both the south half of section 33 and section 1. Bless you.
Thank you.
Yep. In the other township. So we're here hat in hand saying, okay, let's come back to those discussions on the term assignment that we've been tabling for a little bit while we try to understand this bankruptcy. And now we're requesting similar terms that we would like to get an assignment for those interests in exchange for working to expedite to drill this well that can help hold both of our leases. If that's not on the table to XTO, then it is Longfellow's position that we will have to protect and maintain our leasehold, which would include the possibility of drilling a vertical well. XTO mirrored that sentiment by saying that they also could and would drill a vertical well, as well as approach another operator to develop their leasehold for them. So vertical well discussions have always been part of it. It is no secret that we have filed for an APD to have a vertical well. It is Longfellow's position that we would like to protect our interest. And I think a prudent operator would have a vertical well as an option. Specifically, in case they got into a situation like this, where unfortunately timing is of the essence, but we cannot expedite because of a contested hearing. I'm not an engineer. I think Mr. Mitchell will talk about this a little bit later, but although vertical well would be a lot less expensive than drilling a horizontal well and potentially easier to get an APD, there's a lot of benefits of drilling a vertical well, but the very, very major negative of drilling a vertical well is the thought process that it is not the best thing to do for protecting correlative light, preventing waste, and when we could drill a horizontal well that we all know is more prolific.
Turning now to paragraph 23, here Ms. McKee represents that approval of Longfellow's application here would strand acreage in the south half of the southwest quarter of section 33. Isn't the south half of the southwest quarter of section 33 included in the acreage that we seek to pool here?
Yes, ma'am, it is.
Have you also reviewed Mr. Brown's statement?
Yes, ma'am, I have.
Turning now to PDF page 29.
And Ms. Shaheen, you're coming up on 20 minutes in about 1 minute.
This is our last point with Ms.
Go right ahead.
English, unless we need further rebuttal. And so I turn your attention now to paragraph 6B here, where my hand is, and where Mr. Brown is critical of the surface location of the proposed wells. Is that how you understand this testimony?
Yes, ma'am.
And can you just briefly tell the examiners why Longfellow is proposing the surface locations that are proposed?
Yes, ma'am. Yeah, I think we all know that environmental effects, especially in New Mexico, are paramount. And our surface location was chosen and approved with the BLM through on-sites. Sorry, excuse me, the state land office. I don't want to misstate because it is on state land office acreage as the best surface that there is to be getting, to this development. Having our surface off lease, if you may, outside of the unit allows us to put our first take point at the closest proximity. Therefore, we believe preventing the least amount of waste. It's just a simple concept of what I would consider an off-leased surface location, especially with all the environmental effects out there, that it is the best and the most prudent way to develop this.
And what are a couple of the environmental issues that you've had to address with respect to surface locations?
Sure, yeah. And this is, I was not on the on-sites for this, so please keep in mind that this isn't firsthand experience for this particular location, but having worked New Mexico before and at this present day, all sorts of factors between, species of animals that might have, migratory patterns to living around the location to protected cactus. All of these things come into play, as we all know, when reviewing a surface location. And in this particular area, my understanding is that it's particularly a little bit hairy in the respect of there's not a plethora of available locations that don't have at least one environmental concern adjacent or on the location.
And one of those environmental concerns is the sagebrush, the desert sagebrush lizard. Is that correct?
Yes, ma'am, it is. Yes.
And there are also sand dunes present that are an environmental concern. Is that right?
That's correct. Yes.
With that, Mr. Examiner, the only testimony at this point that I anticipate Ms. English would do, it relates to our rebuttal exhibit 1, which has not yet been admitted.
Let me stop you there for a moment. And I would remind Ms. McLean the same thing, so I don't feel like this is unfair. Did you ask your witness to adopt their self-affirmed statement and exhibits under oath, and whether they wanted to make any corrections to them?
Not yet, but I'm happy to do that now.
Go ahead.
Thank you. And your testimony, your direct testimony, Ms. English, is in Exhibit A of Longfellow's exhibits. Is that correct?
Yes, ma'am.
Do you have any corrections to that testimony at this time?
I'm reviewing just to make sure I say this appropriately, so give me 1 second. Rolling through it. No, the only thing that I would like to say, just to make sure that we are all on the same page, is that as of the date of these exhibits, the communication was as it was outlined on the contact list, and there's only been additional communication that has occurred since we put these exhibits in. So I would like for it to be clear that that is not the final contact.
And do you adopt the written testimony as your direct testimony in this matter?
I do.
Thank you. With that, I would pass the witness with the understanding that I can bring her back if need be for additional rebuttal.
Ms. McLean?
Yes, thank you. Good afternoon, Miss English. I'm Jackie McLean. I represent XTO. Let me just, Ms. Shaheen, would you mind stopping sharing so I can do that if I need?
Did it work?
Yes, thank you.
Okay.
Just want to make sure got what we need. All right. Okay, Miss English, you agree that XTO has a working interest ownership in the Van Halen spacing unit, correct?
Correct.
Let me ask you about the North Square Lake unit and the lease expirations. Both XTO's lease and Longfellow's lease were held by production because they were part of that Acacia Remnant North Square Lake unit. Is that correct?
That's my understanding. Yes, ma'am.
So that meant that both XTO and Longfellow's lease were not at a risk of terminating, even though their independent leases did not have production, as long as there was production somewhere within that North Square Lake unit, correct?
That's my understanding. Yes, ma'am.
And as of October 2025, when you brought up the lease expiration concerns to XTO, Longfellow didn't have any production on its leasehold, correct?
That's correct. Yes, ma'am.
And Longfellow, you said, acquired its interest in the acreage that's the subject of this application in 2023 or 2024, correct?
Yes, ma'am.
And Longfellow first proposed the Van Halen wells to XTO in August 2025, correct?
I believe that's the date. I apologize. There's a landman that is on my team who proposed it, so I don't know the exact date. It should be in the
Yes,
context, but that's correct.
Let me show you. I'll go ahead just so that we're very
Yes.
clear.
Yes, ma'am.
It's your exhibit A4. Share my screen. Hold on.
And Miss McLean, I have it now in front of me. If it's easier, I can read it directly from there.
And I can share as well if that would be helpful.
Okay, here, do you see, is this your well proposal letter
Yes, ma'am.
to XTO?
Yes, ma'am.
And it's dated August 1st, 2025?
Yes, ma'am.
So that would be, you know, a year and a half after acquiring an interest in the subject acreage that you proposed these wells?
Yes.
And Longfellow and XTO were discussing developing the Van Halen spacing unit from about August 2025 until present, correct?
Yes, ma'am.
So about 6 months of working pretty diligently on trying to come up with a way to get production on these leases.
Yes, ma'am.
And on January 6, 2026, XTO withdrew its initial protest to Longfellow's pulling application on what you say, quote, assurances that negotiation would continue between the parties. Isn't that true?
That is true. Yes, ma'am.
So at this point, January 6th, XTO and Longfellow were working together to develop this acreage and the Van Halen spacing unit, correct?
We were proposing options and XTO had not agreed to any of the options. So we were in negotiations. Yes.
Well, you had said earlier that you had spent 6 months of working pretty diligently together with XTO on a way to come up, on a way to produce these leases. Are you saying now, no, you weren't working together during that
No,
time?
ma'am. No, ma'am. What I'm saying is, I think it would be just a definition of working together. XTO, as you can see in the Longfellow, as you can see in the contact list, sent the initial will proposal in August of 2025. And then we sent a term assignment offer in October of 2025, and then had multiple contacts over the phone between October and January 6th. So we had proposed a term assignment at that point in time, definitively, but it had not been accepted. So, working together, yes, we were communicating, but there was no alternative options presented by XTO during those communications.
And so are you saying that XTO just didn't respond at all?
No, ma'am, I'm not.
So I guess your definition of working together means that XTO would have just immediately accepted your proposal.
No, ma'am.
So I guess I'm confused on what you're really saying here.
Yeah, sure. So, when we say working together, I'm curious. We proposed at that point in time at least one option for a deal structure. That option had not been accepted by XTO during those months of August to January.
But you had many conversations about that offer, correct? And by January 6th, XTO felt comfortable enough, based on, quote, assurances by you, that negotiations would continue, correct?
Yes, ma'am. Yeah.
Okay. So then a month later, we're at February 3rd, 2026. There's an in-person meeting with Longfellow and XTO, correct?
Yes, ma'am. I would classify that as negotiations continuing.
Okay. That's not what I'm asking, though. You had an in-person meeting with XTO on that date, correct?
Yes, ma'am.
Okay. And at that meeting, you presented what you describe in your testimony as a comprehensive proposal to XTO for developing the Van Halen spacing unit, correct?
Yes, ma'am.
And as part of this comprehensive proposal, XTO was to assign 100% of its interest in the southeast quarter of Section 1, Township 18 South, Range 27 East to Longfellow. Is that correct?
That's correct, with a little bit more to it.
Well, I'm just reading what you have in paragraph 32D of your testimony.
Let me
It
get there
says,
1 second.
and I can put it up too if we need.
Sure. Could you give me a page? I think that would be, I apologize.
Page 23 of the PDF packet.
Okay. Yes, ma'am.
So on this paragraph 32D, you say ExxonMobil would assign 100% of its interest in the southeast corridor of Section 1, Township 18 South, Range 27 East, as discussed in the original October 2025 term assignment, retaining a 2.5% overriding royalty interest, with Longfellow offering to place the Section 1 interest on term to accelerate development.
Yes.
Was there anything apart from that as part of that?
No, yeah, I just wanted to finish that sentence with the retaining the override, because that was the real package. Yes, ma'am, that's correct.
Okay. And so that acreage, the southeast quarter of Section 1, Township 18 South, Range 27 East, is a couple townships over from the Van Halen development, correct?
Yes, ma'am.
And it's actually right by the Marley pad, which your engineer uses as an analog for the production in this acreage, right?
Yes, ma'am.
And the Marley pad is in a more proven area of the Yeso play. Isn't that correct?
You know, I would like to say yes. I'm not a geologist, but from my understanding, yes, there's more wells over there. Yes.
And specifically Longfellow has already producing wells in this area, correct?
That's correct. To the north of that section. Yes, ma'am.
So essentially, you're trying to get XTO to assign you acreage in an area you already have proven results of as a condition of this comprehensive proposal. Is that correct?
No, ma'am. I think what the correct statement in my mind, this is me talking obviously, is that this 32D mirrored the original term assignment that was offered to XTO in October, before we even knew about the acacia, except for a few nuances in the delivery. So the acreage is the same.
Well, I'm not disputing that the acreage is the same. What I'm asking is whether it's in October of 2025 or February of 2026, you are trying to get to trade acreage with XTO in an area where you have already proven well results, and Longfellow has already producing wells, correct?
That's correct. As of February 3rd, 2026.
Right. And by February 3rd, 2026 and October 2025, Longfellow did not have any producing wells in the area that's seeking to pull the Van Halen spacing unit. Is that correct?
That's correct.
So then during the February 3rd meeting, vertical wells come up, right?
Yes, ma'am.
And it was Longfellow that first mentioned vertical wells. Is that correct?
I cannot say that definitively, but I would not deny if that's what somebody else remembers.
Well, during the meeting, your testimony says that you disclosed to XTO that Longfellow was already drilling 5 vertical wells to hold its acreage in other sections. Is that correct?
That's correct.
And you also state that during that meeting, you told XTO that Longfellow could just drill a vertical well in section 33, told its least at a cost materially lower than drilling the Van Halen wells, correct?
That's correct.
And you, quote, emphasized that putting the Van Halen program on the fast track so both XTO and Longfellow could meet lease obligations would involve additional expense and carry meaningful execution and timing risk, correct?
That's correct. Yes, ma'am.
And by timing risk, you meant not producing the wells by July 2026 to meet the lease termination deadline?
Well, I want to take a second on that. By timing risk, I mean, we still had at that point in time the CPO hearing to go through and the administrative concerns of getting APDs. For the expense cost, it would be the expedition of business leases. There's, things that we need to do to fast track these wells. Yes, ma'am.
Okay. And it was unclear at that point if all of that could be accomplished in time for the Van Halen wells to be producing by July 2026, correct?
Yes, ma'am.
And I know, your testimony, you say that you never said you didn't want to pursue the Van Halen spacing unit with XTO, but you did say that you wanted to make clear that if XTO was not to proceed on the terms proposed, Longfellow would need to revisit the matter internally and determine the approach that best aligned with Longfellow's overall interests, correct?
Yes, ma'am.
And I'd like to show you, Sharon, do you want to put this up or you want me? It's one of XTO's exhibits.
Do you know what PDF page number it is?
Yes, I can tell you.
Yeah.
It's our XTO's exhibit A6, which is in the packet that was filed on the OCD website, page 17.
17. Is this it?
This is it. Yes, thank
Okay.
you. So Ms. English, this has been marked as XTO's Exhibit A6. Are you familiar with this email chain?
Yes, ma'am.
And this is an email chain between yourself and various individuals that's at XTO, correct?
Correct.
And the first email, the first page of this exhibit is a response from you to Suzanne Spar and Shelby McKee, among others at XTO. Is that correct?
Yes, ma'am.
And your response is written in blue, right?
Yes, ma'am. Yeah.
And this response was written on February 9th, which is 6 days after that February 3rd meeting, correct?
Yes, ma'am.
And at the end of this page, you say, I'd like to add additional context to the in-person meeting. And this, you're essentially responding to XTO's characterization of the February 3rd meeting. Is that correct?
Yes, ma'am.
Okay. And on this first page, first you set out what Longfellow's proposed deal was, right?
Yes. In those paragraphs. Yes, ma'am.
Yes. Yeah, those bullet points that are at the bottom of that page.
Yes.
That's you setting out what you said was, that comprehensive proposal that you made to XTO during the February 3rd meeting, correct?
Yes, ma'am.
And this basically tracks what's in your written testimony at paragraph 32, right?
I'm going to take your word for it on the paragraph. Yes, ma'am.
And then, Ms. Shaheen, if we could go to the next page of this exhibit. Thank you. So then on this page, the bullet point that starts with Longfellow informed ExxonMobil that we have applied for multiple units as well as multiple vertical wells with the appropriate regulatory bodies. Do you see that?
I do. Yes, ma'am.
So again, in this email from February 9th, just a few days after that February 3rd meeting, you are reiterating that you applied for multiple vertical well permits, correct?
Yes, ma'am. Yep.
And then the bullet point below, you said you're already drilling 5 vertical wells to hold your acreage in other sections, correct?
Yes.
And that Longfellow advised ExxonMobil that Longfellow could elect to drill a vertical well in section 33 to satisfy leasehold obligations at a cost materially lower than drilling the Van Halen wells, correct?
Yes, ma'am.
And then at the end of that bullet point, you didn't include this in your written testimony, but in this email you say the question remains whether such an accelerated schedule is achievable, meaning you weren't sure whether you could do these, get the Van Halen wells producing by that July 2026 deadline, right?
What is the date of this email?
This was from February 9th.
And so this was, my understanding is when I drafted this email, this was after the protest had come out with the CPO by XTO. So yes, that statement is true. And it has to be surrounding that we were then going to go to a contested hearing, which we all know is taking time.
Okay, so again, the question I asked was, when you say in this February 9th email, the question remains whether such an accelerated schedule is achievable, is that Longfellow was not sure as of February 9th that it could meet that July 2026 production deadline, correct?
That's correct.
Okay. And then you go on to say, again, as you did in your direct testimony, the next bullet point down, that you made it clear that if ExxonMobil is not prepared to proceed on the terms that Longfellow proposed, Longfellow would need to revisit the matter internally and determine the approach that best aligns with Longfellow's overall interests, correct?
Yes, ma'am.
So by the end of the day on February 9th, you had told XTO twice that Longfellow was currently drilling 5 vertical wells to hold its acreage in other sections, correct?
I think it was on February 3rd.
So I'm saying by February 9th. So, February 3rd plus February 9th. At this point, you had told XTO twice that Longfellow was currently drilling 5 vertical wells to hold its acreage in other sections.
Yes, and I want to be clear about something. We had at that time filed for APDs. So
Yes,
we were not currently drilling. We were filing for APDs and had the plans to, pending the approval of those APDs, execute drilling of those 5 vertical wells.
So then your email of February 9th, where you say Longfellow discussed that we are already drilling 5 vertical wells, and then your sworn testimony at paragraph 34, where again you say I disclosed that Longfellow was already drilling 5 vertical wells. Those are incorrect statements.
Well, I think already drilling, that's a verb, but this is talking about in the future, we would be drilling. So I guess we could say that that's an incorrect statement. It would, to me, seem like that's saying the proposed plan is to drill already, meaning we would have a rig out, a vertical rig, those 5 vertical wells.
Well, let's pull up your sworn statement because I don't think it's your already, but let's just look at what you said.
Okay.
Ms. Shaheen, do you want to share or do you want me to share that?
Yeah, just tell me which PDF page number.
It's your Longfellow's exhibits at page 24.
All right, here we are.
Okay, great. So paragraph 34, the first sentence, also during the February 3rd, 2026 meeting, I informed ExxonMobil that Longfellow had applied for multiple units and multiple vertical wells with the appropriate regulatory bodies, correct?
That's right. Yes, ma'am.
So that sentence is saying that you informed them that you had applied for permits, correct, for vertical wells?
That's right. Yes, ma'am.
Okay, then the next sentence, I disclosed that Longfellow was already drilling 5 vertical wells to hold its acreage in other sections. And then if we skip, and that Longfellow could elect to drill a vertical well in section 33. So this sentence, can you tell me how it's wrong to characterize this as you disclosed to XTO that Longfellow was already drilling 5 vertical wells?
Yeah. Look, I won't sit here and argue about the words already drilling, whether that means already drilling in the future, as in that's part of our plan, or already drilling as in we had spud 5 vertical wells. It's undisputed that at the time of this meeting and in my testimony that we are not currently with a bit in the ground drilling 5 vertical wells. I greatly apologize if that sentence is misleading. I read that sentence as we disclosed that we were already going to drill 5 vertical wells in the area between now and July to hold leases, including third-party leases. Now,
Well,
if that's
could you see how someone reading an email that says, I disclosed that Longfellow was already drilling 5 vertical wells to hold its acreage would believe that to mean that you are currently drilling 5 vertical wells?
Yes, absolutely. And to my counterparts at XTO, I was never aware that that's what you guys took this as, since we've never discussed that. I apologize. What that means is the plan was to drill 5 vertical wells. I apologize for any confusion to anybody that we were currently drilling 5 vertical wells.
So let's go back to the initial question. By February 9th, you had relayed to XTO twice that Longfellow was, quote, already drilling 5 vertical wells to hold its acreage in other sections, correct?
Yes, ma'am.
And by February 9th, you had told XTO twice that Longfellow had applied for multiple vertical well permits, correct?
Yes, ma'am.
And by February 9th, you had told XTO twice that Longfellow could go drill a vertical well in section 33 to hold its lease at a cost materially lower than drilling the Van Halen horizontal wells, correct?
Yes, ma'am.
And you had also told XTO twice that Longfellow wasn't sure an accelerated drilling schedule for the Van Halen wells was possible to hit that July 2026 lease expiration. Is that correct?
Yes, ma'am.
So you don't dispute that Longfellow told XTO at least twice that it was going to drill vertical wells to hold its acreage in at least 5 other locations. Is that correct?
That we had filed for APDs, yes, and that the plan was potentially, we could drill 5 vertical wells. I apologize for this confusion. I'm having a hard time understanding the relevance. These are wells outside of
And
this section.
I don't think that you can object to relevance.
Oh, sure. I apologize.
And again, this goes to, as you've heard, XTO has doubt whether this Van Halen spacing unit will actually be executed. And this goes to our evidence to show that there were multiple instances where Longfellow said that they were drilling vertical wells in other areas. Longfellow brought up the idea of vertical wells. And this came as a surprise to XTO, who had been diligently working.
I'm
with
going to
Longfellow.
object because Ms. McLean is testifying.
I'm on my pad now, so it's a little different here. Ms. McLean, your response?
I'll withdraw it.
Thank you, Ms. McLean. All right, so is there so just to be clear, Ms. English, when it comes to relevance, that doesn't really apply when a witness is being questioned to bring out their credibility, okay?
Yes, absolutely.
So Ms. McLean has wide latitude to question you so that the fact finder, Mr. Garcia, and myself can determine the reliability of your statements, because that goes to the weight of your testimony. But I feel like we all understand at this point, at least I can speak for myself, what you said and what maybe you should have said. I don't know if Miss Shaheen is going to redirect you on this, and whether Miss Shaheen is going to want to submit a revised exhibit possibly to clean that up. But Miss McLean, do you want to move on?
Yes, thank you.
I'm not sure what are we looking at? Okay, thank you.
And Miss English, you would agree that drilling the Van Halen horizontal wells is not the only option to hold both XTOs and Longfellow's leases, correct?
Yes, ma'am.
Let's go to paragraph 56 of your testimony. And that's on page 29 of the PDF. Okay, do you see paragraph 56?
Yes, ma'am.
And about halfway through this paragraph, you say that despite being on notice of the lease expiration risk for several months, XTO has taken no independent action to preserve its leasehold, correct?
Yes, ma'am.
But in your testimony, you detail months of negotiations between XTO and Longfellow to attempt to come to an agreement to drill wells on this lease, right?
Yes.
And if the Van Halen wells were drilled and producing by July 2026, this would preserve the XTO lease, correct?
That's right.
And you also mentioned in your testimony that XTO had contacted MAC to re-permit already approved wells in the south half of section 32 to penetrate and produce from XTO's leasehold. Is that correct?
That's coming from XTO. That's
Well,
what they told us.
If we go to paragraph 49, which is on page 28 of the PDF, you say, as noted in paragraph 35, ExxonMobil's only affirmative action with respect to the development of its acreage has been to approach MAC to request that MAC re-permit its already approved wells in the south half of section 32 to penetrate and produce from ExxonMobil's leasehold in section 33, or to have MAC drill a vertical well. That's your testimony, correct?
Yes, ma'am.
And so you say there has been, quote, an affirmative action to develop Exxon's acreage, correct?
Yes, sure. I think, yes, they have, this was coming from XTO that they had approached MAC, so we're taking their word for it. Yes, ma'am.
Well, you're characterizing, though, that as Exxon's only affirmative action to develop its acreage, correct?
Yes.
So that affirmative action on the part of XTO would be some sort of action to preserve its leasehold. Isn't that right?
That's right.
Then I want to ask briefly, you were confused in your direct testimony about Ms. McKee's statement that XTO emailed Longfellow to confirm that Longfellow would not pull XTO's interests. Do you remember that?
Yes, I do.
Can we go, it's XTO's Exhibit A4, which is page 14 of the PDF of exhibits.
Is that it?
So this is the last page of Exhibit A4, which is another email chain. And this was the first email in the chain at the bottom of the PDF. Do you recall receiving this email on January 7th?
I do.
And in the email, Exxon says, Happy New Year. I wanted to make sure you received outside counsel's removal of our protest on Van Halen. Additionally, would you confirm Longfellow will be removing us from the order as we work through other commercial arrangements? Do you see that?
I do.
And if we go to the next page up, so yes. And I'll give you time to look through that. And then you can answer whether you ever responded to XTO about whether you'd be removing them as a pooled party.
Can you repeat the question? I apologize.
Yes, so in this January 8th response to XTO's January 7th inquiry about whether you confirm that you were removing them as a pooled party, did you confirm that Longfellow had done that or would be doing that?
No, ma'am, I did not.
And then let's go the next email up on this page.
Oh, here?
No, it's still that second page. Yes, perfect. Right there is fine. This is another January 8th email to you from XTO. And that first paragraph, thanks for the update. I hope things went well for Longfellow today. We do prefer to work in agreement rather than be subject to an order. Do you see that?
I do. Yes, ma'am.
And the next email up, if you want to read, and then let me know if you ever responded to them about removing them as a pooled party.
No, ma'am, not in the email.
Okay. And then the surface location that you spoke to briefly in your direct testimony. I'd like to, have you had a chance to review XTO's rebuttal exhibit A8?
Presumably yes, but I don't have it. Let me take a second.
I
Apologies.
believe that's has not yet been admitted into the record.
Well, I'm going to try and get it admitted through Miss English here.
Okay, I'm sorry. Let me just make sure I understand, because I thought we had objected to XTO's rebuttal exhibit A8.
Yes, but I think, even though, I mean, I guess, what would you prefer? Would you prefer for me to try and introduce it through my witness? I think that it's relevant, and she's opened the door to this with her surface location testimony, which is why this was submitted as a rebuttal exhibit to begin with. And I think it would be appropriate to address with Miss English.
Give me a minute here to look at it. So you're talking about XTO's rebuttal exhibit A8, and we've objected to that. And until you get it admitted into the evidence, I don't believe you can cross-examine Ms. English about it.
Well, I'm trying. We have introduced it as rebuttal to Miss English's testimony, correct? And she has, I believe, opened the door for us to ask about this C-102 on cross-examination. I can wait and come back and ask her about it again if you want me to do that. But in the interest of time, and if the hearing examiner permits, I do think it would be appropriate to try and introduce at this juncture.
Okay, well, I object to introduction of that exhibit, and I'm happy to tell you why if now is the appropriate time.
Okay, since Ms. McLean is trying to get an objected exhibit admitted, let me ask a question first. Ms. McLean, which witness developed exhibit A8?
Well, this is it was not developed by any witness. It is a public filing of a C-102 for Mac's proposed well. And Miss English in her testimony had said that there were surface location issues. And this C-102 show the surface location that Mac has already had approved by the BLM. We feel rebuts her statement. And I was going to ask our land witness, Miss McKee, about this exhibit as well.
All right. So, so this is not an exhibit. So I'm just trying to understand the legal background for this exhibit first. This was not developed by any of your witnesses. It's a witness that you found in the public forum, which you believe helps your case because it in some way discredits Miss English testimony. Is that right?
Somewhat. I just want to make clear that it wasn't like by happenstance that we found this in the public forum. We have been working with Mac. Mac has filed.
I'm going to object again because Ms. McLean is testifying about facts related to an exhibit that I've objected to, and I'm happy to state my objection to that exhibit whenever you're ready.
I'm happy to hear. Hold on. I'm happy to hear your objection, Ms. Shaheen. However, if we were dealing with the rules of evidence, this would be a Rule 104, and specifically would be subsection B. And as a trial attorney, I dealt with this all the time in providing foundation for an exhibit to come in. Rule 104B allows hearsay testimony to establish a foundation. Of course, the rules of evidence don't apply here. So I'm not even worried about specifically Rule 104, but I understand what Ms. McLean is doing. And what I'm trying to find out is more about this exhibit because I know nothing about A8 it was objected to, and it's not in evidence. Your objection, Ms. Shaheen, is that she shouldn't be using it to cross-examine your witness because it's not in evidence, and that's a good point. However, Ms. McLean is saying, well, for the sake of time management, why don't we see if we can get the exhibit in? On top of that, Ms. McLean is saying that your witness opened the door to this issue, and so she should be able to bring it in.
Well, I'm sorry, I
Go
just
ahead.
haven't been able to state my objection yet.
Please,
So
go ahead.
I'd like
Ms.
to
Shaheen,
state my objection.
Ms. Shaheen,
Okay.
I'm just reiterating what I understand so far. I'm certainly going to give you an opportunity to speak, and now is a good time.
Okay, great. So these objections relate to both rebuttal exhibits A8 and B7. These were filed yesterday afternoon at like between 1 and 1:30. These exhibits appear to constitute a quote competing proposal, which was offered to the division by XTO less than 24 hours ago. These exhibits result in unfair surprise and prejudice to Longfellow. This is particularly true where we have this imminent lease expirations. Apparently, Exhibit A6 has been available to XTO since February 9th, more than 20 days ago, and 10 days prior to the deadline for filing the parties' exhibit packages. Any so-called competing proposal should have been included in the direct testimony at the latest. Moreover, this is simply a proposal to drill 158 feet into the southwest quarter of the acreage Longfellow proposes to develop. It does not include the remaining acreage that Longfellow proposes to develop, and thus does not preserve Longfellow's lease. These exhibits simply illustrate the bad faith conduct of XTO in this matter since they received the well proposal in August 2025. The belated assertion of a purported alternative development filed less than 24 hours prior to the hearing should not be condoned, and these exhibits should be excluded from the record.
Okay, so I'm confused, Ms. McLean. Maybe you can help me understand something that Ms. Shaheen just said. I don't understand the competing proposals. What is she talking about?
I don't know either. This is not a competing proposal. We're not presenting it as a quote, proposal that the division needs to look at with all its 7 factors. This is going to show, one, like I've already said, I am trying to get this in through Miss English to show the surface location issues, rebut that testimony, that Longfellow had questioned our quote independent action to do anything with regard to the spacing unit. As Miss Shaheen so diligently pointed out, this is dated February 9th, 2026. As we've established through testimony, ad nauseum, by February 9th, 2026, Miss English had informed XTO at least twice that they had gotten permits to drill vertical wells to hold their acreage, that they were, quote, drilling vertical wells to hold their acreage. And at that point, XTO said, we got to get the move on trying to do something to hold our own lease. That's when this became a very real scenario that they didn't think Longfellow would drill these wells, and why they reached out to MAC to amend their already approved APD to include this perfing, this acreage in their lease. That's why we're introducing it. It's of absolutely no surprise to Longfellow as they themselves testify about MAC and XTO's reaching out to MAC to help them hold their lease. Again, I believe that Miss English has opened the door for me to introduce this exhibit A8, at least now for the purpose of rebutting that surface location testimony.
And I'm not sure which testimony you're rebutting. If you could be very specific about that, would be helpful.
So Ms. Shaheen, hold on, Ms. McLean. So I don't want the parties sort of arguing with each other. If you have a position, Ms. Shaheen, address me. I'll address Ms. McLean. Ms. McLean, right now I'm looking at the rule and I'm looking for the deadlines for exhibits, because Ms. Shaheen has brought up the idea that, you know, you filed this yesterday, it's a surprise. I know you're saying it shouldn't be a surprise, but however, I am looking for the rule.
Here,
I do see in 1915-413 where it talks about exhibits. And Ms. Shaheen, I think you should look at this rule as well. But Ms. McLean, where is the deadline for exhibits?
there is none, and funny you should bring that up. I actually reached out to Ms. Shaheen on Monday to see if she would agree to a mutual deadline of 5 p.m. Tuesday to exchange exhibits, and she said absolutely not. She would never hold herself to such a deadline when none is required or ordered by the division. So I said, okay, I understand. And so we got ours together, filed them yesterday around lunchtime. They filed another rebuttal exhibit, their rebuttal exhibit A2, after we filed ours. We haven't objected to that. We aren't saying it's a surprise. We're expecting them to file some more things. So it's just really disingenuous when I had asked if we could agree upon a deadline and she flat out refused, to now be saying she's surprised that we're filing, and we filed less than 24 hours when she did the exact same thing.
So, Ms. Shaheen, I'm looking here at the rule I just cited, 1915-413 B2. That's the closest I can find to anything that talks about a deadline. It seems like the rules are very permissible when it comes to offering evidence at a hearing. It says a party other than the applicant shall include in its pre-hearing statement a statement of the extent to which the party supports or opposes the issuance of the order the applicant seeks and the reasons for such support or opposition. In cases to be heard by the commission, each party shall include copies of exhibits that it proposes to offer in evidence at the hearing with the pre-hearing statement. So there's a certain amount of days before. The commission may exclude witnesses the party did not identify in the pre-hearing statement or exhibits the party did not file and serve with the pre-hearing statement unless the party offers such evidence solely for rebuttal or makes a satisfactory showing of good cause for failure to disclose the witness or the exhibit. That's the only deadline I can find. Do you know of any other?
There are no deadlines for rebuttal exhibits in the
Okay.
pre-hearing order. However, I think I still can rely for guidance on the rules of evidence that prohibit use of an exhibit that constitutes unfair surprise or prejudice.
Okay.
And I know that I understand Ms. McLean's argument that there's no unfair surprise here because we knew about discussions with MAC, but what we did not know is that there was an APD that had been filed. And yet they knew that an APD had been filed as of February 9th and failed to disclose that.
Okay. So let me ask this question to the parties. Maybe this is a good compromise. Ms. McLean, instead of cross-examining this witness on A8 at this time, why not bring in A8 during your case in chief? And then we can recall Miss English and you can question her about A8 if it comes in at that time.
Sure, I'm happy to do that.
That way also Miss Shaheen and Miss English have an opportunity to look at A8 carefully and discuss it and go from there. Does that sound fair, Miss Shaheen?
We will work with that.
That doesn't answer my question, but okay. Okay, so Miss McLean, you were cross-examining Miss English.
Yes.
Do you want to continue?
Yes, I just am going to have one or two more questions.
Please, go ahead.
And I think that these are particularly important, especially at this juncture, since we have this MAC C102. Ms. English, at paragraph 49 of your testimony, you state that ExxonMobil's only affirmative action with respect to the development of its acreage in the horizontal spacing unit has been to approach MAC, a third-party operator, to request that MAC re-permit its already approved wells in the south half of Section 32 to penetrate and produce from ExxonMobil's leasehold in Section 33. Do you see where you've said that?
I do.
So at the time you filed this testimony, which is February 20th, 2026, was it your understanding that MAC had already approved permits for wells in the south half of section 32?
It was my understanding that they already had approved permits.
Okay, and was it your understanding that XTO had was planning on asking MAC to re-permit their already approved permits to penetrate and produce from section 33?
I apologize if this is the wrong wording, but it was my understanding that they would sundry or change, amend. So I don't know if that's considered a re-permit, but something to that degree.
Right. So that's fine language. So as of February 20th, last Thursday, it was your understanding that XTO was planning on requesting that MAC change its already approved permits to include penetrating section 32 in addition to section 33. Is that correct?
That was my understanding. Yes, ma'am.
Okay, thank you. I have no more questions, but I do reserve the right to recall Miss English for that rebuttal exhibit A8. Oh, you're on mute, hearing examiner.
Thank you. I don't know how it got on mute. The parties do not need to reserve the right to recall witnesses. That will always be allowed unless there's a valid objection to it. So both parties do not need to do that. Mr. Garcia, questions?
I have a few. Good afternoon, Miss English. I was going to.
Good afternoon.
I am not a landman, so bear with some of my questions.
Sure.
All the land in yellow is Longfellows. The black outline represents basically what I'll call the old Acacia unit. I guess my question is, with BLM, I am not an expert with BLM's leases. Does the development plan for this case that we're discussing hold all this acreage, or is it just the acreage that the wells penetrate?
Just the acreage that the wells penetrate, subject to the lease. So if the lease, I'll use XTO's acreage as the example. You can see the lease number NMLC 56302B. We put on all of the tracks. You can see that their lease covers, it's 800 acres is what their lease covers. So one well would hold all of the lease 302B, which is every XTO tract with the exception of that east half of the northwest quarter of section 28. So one well, yes, sir, would hold the entirety of the BLM lease that XTO has. In our case, similar concept, but much less acreage. Our lease is just in section 33. So our one well that's in dispute would hold just those 4 tracks that we have in section 33.
The ending in 681s.
Yes, sir. Yeah.
Okay. I guess on that point, the 5 wells that you guys discussed extensively that are to be drilled in the future, those are basically in order to cover the leases that don't end in 6.8 then. Is that correct?
That's correct, sir. Yes.
Okay. And then I'm just looking at my notes. Has BLM, I guess, again, not BLM expert, have they outright stated that if this lease expires that they won't reissue it until the bankruptcy's resolved in, I think you guys estimated 2029?
Yeah, they have, and I giggle because who is a BLM expert? I certainly am not. So I just have my communications with them. They're I can give you names if we need, but the people who I've been speaking with at the BLM have indeed said that their counsel internally at the BLM has requested that the leases would not quote terminate per the unit until the until the bankruptcy proceedings have run their course, even though the leases would technically be terminated. So these are their words. But in other words, the leases would terminate in July of this year, but they wouldn't go back into auction until the bankruptcy proceedings have been finalized, which the reason we estimate such a long period is because this bankruptcy covers much larger than this unit. I think it covers about 450 wells, and please, the attorneys will know more than me on this, but I think it's about 450 wells across several counties. And so it's going to be quite an extensive Chapter 7 proceeding.
Okay. I guess on that, I'm assuming BLM isn't open to like Longfellow asking for an extension of the lease then?
It's a great question. We have requested many times, and the BLM has been very helpful. I will say my understanding from my communications with them is that they're very, very, very much wanting wells to go in the ground to hold these leases, because they do think that this bankruptcy is going to be quite hairy and perhaps take some time. So they're very supportive of getting wells in the ground, and that comes out in their statements that they would do everything they can to, expedite APDs and try to help move the process along. But in terms of your direct question, unfortunately, at the end of the day, the only thing that they do, they've said this, they can't, make deals and negotiate a new contract. It has to come down to the lease, four corners of the lease. And unfortunately, there's just no provision that could give us an extension.
Okay. And if you can't answer this, let me know. This might be more a
Sure.
council question. Has Longfellow ever asked for like a leave in the bankruptcy court proceedings in regards to this lease?
Yes, so we have, sir, we have reached out to the trustee of the bankruptcy in our long-winded attempt to come up with a solution. As you've read, I presented to XTO and said, we think we came up with a solution. We think you saw that in italics. That was the product of conversations with the BLM, the trustee of the bankruptcy proceeding, and all of the third-party operators. So we did interject into the bankruptcy and attempt to come up with something with the bankruptcy proceeding. It gets very tricky, and to keep you out of all of the muddiness of it, one of the things we requested was simply, is there a way that we could produce some of the wells in the unit? What if we come in and we attempt to do that? That was one of the things we threw out there. Unfortunately, with the BLM, you cannot have multiple operators within a unit. This is, again, I'm no expert. This is just me regurgitating my conversations with the BLM. So we are not, Longfellow is not a party to the unit right now. We only have rights in the YESO. And so unfortunately, we don't have an availability to interject and produce from the Acacia unit to hold these leases.
Okay, no, appreciate it. I think this is my last question. I talk to BLM often, and that's why I'm not expert, because I rely on them heavily. I know
Same.
BLM's heavily in talks with operators about orphan wells, and since this lease has a lot of potential orphan wells or facilities, assets, etc., I guess has BLM talked to Longfellow or vice versa about any dealing with those assets, I guess?
Yeah, that's a good question. They have not. They haven't approached us in my conversations. That has not come up, simply because Longfellow is not a record title owner. We have operating rights, and as you may know, the record title of the federal lease is ultimately liable for helping remediate and plug wells, along with the operating rights owner in the unit, which again, Longfellow is not a party to the unit. So they have not reached out and asked us to take on liability. With that said, we have discussed some of that even with XTO just today. So that's an ongoing discussion, but it is hard because Longfellow would prefer not to take on plugging liability. It's the remediation that needs a very good review, and we would be willing to work with parties, but we would also not want to take on the whole unit or all of the wells, anything like that to try to clean it up because we just don't know what that implies.
Yeah, understood. I believe that's all my questions. Thank you.
All right. Ms. Shaheen, before you do redirect, I'd like to take a 5-minute break.
Okay.
All right, we'll be back. All right, Ms. Shaheen, let's see, what time is it? It is 2:06 p.m. and we're here for your redirect of Miss English.
Thank you. I don't have a whole lot, so that's the good news. Ms. English, you recall the discussion about your paragraph 34, and I will share this. In particular, the second sentence in paragraph 34, I disclosed that LFE was already drilling 5 vertical wells to hold its acreage in other sections. So here, you did not represent that Longfellow was already drilling a vertical well in the subject acreage here, right?
That's correct.
Objection. This is not redirect because I never asked her if she represented if Longfellow was drilling a vertical well in section 33. It was always to hold its acreage in other sections. And then separately, that Longfellow could elect to drill a vertical well in section 33.
Ms. Shaheen?
The impression that I received after listening to the long discussion about this was that Ms. McLean was suggesting that XTO believed that Longfellow was going to be drilling within the subject acreage a vertical well. And I'm just clarifying for the record that that is not what Ms. English's testimony says.
I believe, and my door is open because this room is getting too hot with the door closed. So if you hear noise, I apologize. I believe that your witness, Miss English, clarified that the language she used in her self-affirmed statement was somewhat misleading. She admitted to that, and she clarified what she really meant. I don't think there's really any issue here. So I sustain that objection. Why don't you go on to another subject in your redirect?
Ms. English, you've reviewed Ms. McKee's testimony regarding Longfellow's rigs in New Mexico, have you not?
Yes, ma'am, I have.
Turning now to XTO's exhibit. This is PDF page 3.
Objection. Again, I don't see how this is rebuttal. I never asked, or redirect, I never asked Miss English about Longfellow's rigs in New Mexico. She could have done this on her direct and her rebuttal testimony.
Ms. Shaheen?
Well, I believe I have the right to bring back Ms. English to do additional rebuttal testimony. And if you want me to wait until after Ms. McKee has testified about the rig availability, that's fine. But I think I certainly have the right to ask her about Ms. Shelby's statements regarding rig availability at some point. We can do it now or we can do it later.
Ms. Shaheen, I agree that this isn't correct redirect because this was not asked on cross-examination by either Mr. Garcia or Ms. McLean. So why don't you call her back after the other witness testifies? I agree.
Well, except I will say that this actually goes to this discussion about already drilling vertical wells. This relates to that. So in that sense, it is redirect.
Okay, well then, if that's the argument you're making, then make it so that I can make a ruling. How does it relate to the already drilling?
Well, that you're asking me that is a bit of a request for me to testify, but it relates because they knew that Longfellow was not already drilling because they're testifying that Longfellow did not have a rig operating in New Mexico.
But Ms. Shaheen, we've already clarified. Your witness has already clarified what she meant in that paragraph. I don't know that we need to belabor this back and forth about already drilling or will be drilling in the future or whatever. So I really think this subject, unless something comes out on Ms. McLean's case in chief or rebuttal case that you need to rebut, I don't see the issue here anymore.
The issue is that I believe Ms. McLean is using this testimony to justify XTO's apparent belief that Longfellow wasn't going to drill the horizontal wells because it was going to drill a vertical well. And that's just simply not true.
Okay, now that being said, let's wait until Ms. McLean's witnesses say that, and you can cross-examine their witnesses if they say that, and you can bring rebuttal testimony if they say something you're surprised about. But at this point, we have the evidence from your witness as to what Longfellow's intents were. I don't see the point of belaboring this. So do you have other redirect besides this will be drilling or has drilled or whatever?
I do not.
Okay, very good. All right. Okay, so may we excuse this witness at least temporarily?
Yes.
All right. Why don't we thank you, Miss English, and we may see you again later or tomorrow or something of that nature. Why don't we bring in your other witness, Miss Shaheen, that you said needs to testify today?
Yes, Mr. DeHammer.
There we are. I see him. Mr. DeHammer, I remind you that you are under oath.
Yes, Mr. Commissioner.
Go right ahead, Machine, and I'll start the 15 minutes. In case you need more, let me know.
I will. And so we're turning now to PDF page 81 of Longfellow's exhibits. Our PDF page 80. Good afternoon, Mr. DeHammer.
Good afternoon.
And I'll ask first, this is your exhibit B, PDF page 80, and the related sub-exhibits, B1 through B5. Do you adopt this as this written testimony as your direct testimony in this case?
Yes, ma'am.
And I should have asked this question before. Do you have any corrections to this testimony?
No, ma'am.
And here you have the usual geology exhibits here. B1, a general location map. B2, a subsea structure map and cross-section map. And I'll turn to the exhibits now. B2, your Yeso structure map. B3, your Yeso cross-section. And here, can you describe to the examiners the proposed development within the Yeso formation?
Yeah, in the Van Halen unit, we propose 3 landing zones within the Yeso formation that has a gross thickness of 1,400 feet. Those landing zones we describe as a paddock landing zone and 2 blindberry landing zones. You'll see that the paddock landing zone is roughly 350 feet thick, and the blindberry, or 400 feet thick, and the blindberry, the remaining of the Yeso, and accommodates more than one target.
And so your gun barrel here at exhibit B4 illustrates the various targets throughout that 1,400 thick Yeso formation. Is that right?
That's correct. It shows our staggered development pattern, which is becoming standard in our local hills area to be applied here.
And you've used similar development plans elsewhere. Is that right?
That's correct.
And then your exhibit B5 is your gross isopac map here. Is there anything in particular that you think is good to point out?
Just relevance of the thickness kind of continuing. You see the wells that are drilled immediately offset the proposed unit. Those are also paddock and blindberry development. albeit from 2014, 2015. So we have a lot of confidence in this area due to the offset production. And I believe we have another exhibit that kind of shows that all 3 benches have been targeted.
Is that exhibit B6?
Yes, ma'am. So as you can see, the previous historically 3 bench development has kind of been proven in the immediately offset area. So we think that 3 wells within the kind of more dense spacing within the CD is adequate for this area and helps us drain the reservoir to our best abilities.
I have no further questions of Mr. DeHammer, and I pass the witness for cross.
Thank you, Ms. Shaheen. Now, the one thing I'm wondering, Ms. Shaheen, I don't remember you are asking if he adopts under oath his self-affirmed statement and the accuracy of his exhibits.
I believe I did, but I'll do it again. Do you have any
Well,
corrections, Mr. DeHammer, to your exhibit B, your self-affirmed statement, and the sub-exhibits related thereto?
No, ma'am.
And do you adopt this testimony as your written testimony in this matter?
I do.
Thank you. Okay, Ms. McLean.
No questions for this witness.
Oh, that's right. You said originally that you weren't going to have questions. I don't know. I thought you might change your mind. And then Mr. Garcia.
Should I change my mind just for fun?
You did actually. You said I won't have any questions, and now I remember you said that. Mr. Garcia.
I think I just have one question. Mr. DeHammer, hopefully I read all of your good exhibits right. Is it Longfellow's plan to drill 1 well because of timelines you guys are under with the lease, and then come back and drill the remaining wells? Is that correct?
That is the plan. Yeah.
Okay, just want to make sure. Okay, so that's not my question. My real question is, I guess, with that drilling 1 well, completing it, coming back and doing the rest of the wells, do you have any concerns about like production drawdown, or I guess what most people call like parent-child effects?
No, we've developed the YESO kind of in other areas with 1 or 2 wells per bench, and then come back and finish out the pad, and we see adequate production.
I think you said it was like 1,400 foot thick here, so basically you're not worried about any production drawbacks because of the fast timeline you're under.
No, and our engineer can speak to this in his testimony if need be, but in terms of, we take operational kind of measures to make sure our production remains online and at its best.
I think you answered it sufficient for me. No other questions.
Mr.
All right,
Examiner,
thank you. Yes.
I apologize, but I did not get to Mr. DeHammer's rebuttal
Okay.
of XTO's statements. I apologize. If I could have the opportunity to do that, I
Yes,
would
please,
appreciate
go ahead.
it. Okay,
Go right
great. Mr. DeHammer, have you reviewed the testimony of Ms. McKee and Mr. Brown?
Yes.
And so turning now to, well, actually, this is paragraph 10, and perhaps I'm not going to be allowed to ask this question. I did have it as a rebuttal question.
Paragraph 10 of his testimony or of someone else's
Of
testimony?
Mr. McKee's testimony, Ms. McKee's testimony.
Okay.
Oh, here I'm in the wrong exhibit. So let me see which page this is on. Here it is. This is the rig availability. This is the rig availability question. So I do have I will save that question for Mr. Mitchell, who will address it with respect to a different subject. Turning
so-
to Ms.
Oh, you're still going? Okay.
Okay, turning to paragraph 24 in Ms. McKee's testimony. Here, Ms. McKee testifies that the estimated cost of the proposed Van Halen wells are not fair, not reasonable, and not comparable to the cost of other wells of similar length in Eddy County. Do you have any response to that statement, Mr. DeHammer?
I think that response would be best left to our engineering expert, Mr.
Oh,
Mitchell, if
okay.
that's okay.
All right. And then I
My
have,
response would be, we drill good wells and our costs are in line with what we do.
okay, so my next topic here is rebuttal, Longfellow's rebuttal exhibit 2. And let me see if that is for you or for Mr. Oh, this looks like it's for Mr. Mitchell. Turning to paragraph 6A of Mr. Brown. Okay, and I'll share.
And can you repeat where you are?
Yeah, I'm on PDF page 29 and it's actually 7A.
Of XTO's exhibits?
Yes.
Okay, thank you. Do you want me to share?
I'll share. I'm almost there. Okay, paragraph 7A. Have you reviewed this testimony of Mr. Brown?
All right, let me just make sure I have real quick. Yes, ma'am.
And do you have a response to his testimony in paragraph 7A, specifically in the first sentence?
Yeah. The comparison he's trying to make is to development that was done in kind of what we'll call Gen 1 YESO development. Immediately to the south, these were 8 wells per section. They were stacked on top of each other within the section, so no lateral offset. In the following 12 years, YESO operators, including Longfellow and other operators, have kind of adopted the staggered model on 2 to 3 bench development that we've seen. Again, this is a good area within the platform, and we view the better areas to be able to accommodate 3 wells per section from a reservoir quality.
And turning now to paragraph 7B, again, the first sentence here, do you have any rebuttal to this statement regarding unproductive lateral?
Yeah, again, as Ms. English testified to, this is an environmentally sensitive area, and so we need to have our surface locations where they're at. And that's the reason for the kind of extended length of measured depth that we see pretty much in the Cedar Lake area. We're trying to minimize our impact on the surface.
Anything else that you would like to say in response to Ms. McKee's or Mr. Brown's testimony?
No, just like I said, this is a high confidence area for Longfellow. We view this area as good as any other area on the shelf, and we are taking our concepts to this spot as well.
Thank you, Mr. DeHammer, and I really do pass the witness this time.
And I do have just one question based on his testimony.
Go right ahead.
Thank you. Mr. DeHammer, are you aware of any developments in the surrounding, in the acreage surrounding Van Halen that have 16 wells per section in the YESO?
No, ma'am.
Okay, that's the only question we have. Thank you.
Mr. Garcia?
No other questions.
Thank you. All right, Ms. Shaheen, may this witness be excused?
Yes, he may.
All right, thank you, Mr. DeHammer. And Ms. Shaheen, that leaves Mr. Mitchell.
That is correct.
Mr. Mitchell, I remind you, you're still under oath.
I understand. Thank you.
Thank you.
Mr. Mitchell, I'll start by asking you if Exhibit C represents your written testimony, direct testimony in this matter.
It does.
And the sub-exhibit C1 through, let's see. C1 through C8.
Yes, yes, ma'am.
And do you have any corrections to that testimony?
No, ma'am.
And do you adopt that testimony as your direct testimony in this matter?
I do.
So here in on PDF page 92, you discuss Longfellow's history of well performance and operational capability. Can you hit the high points for us in paragraphs 5 through 8?
Sure. So first of all, thanks very much for hearing my testimony. Longfellow's been operating in Eddy County since about 2018. We've drilled over 30 laterals in the Yeso trend, which is what the formations that's under discussion here. We have a slightly different operating strategy than some of the other operators in the play, and it requires much larger fluid loadings, much bigger fracs, just to put simply, and we've achieved much higher reserves per lateral foot than our offset competitors. When we look at all the horizontals in Eddy County, including all other formations of interest, including the basin, which includes the Wolfcamp and the Bone Springs and very prolific plays, of the 50 best wells in an EUR per lateral foot basis, Longfellow holds 8 as per Drilling Info Enervis public release data. So we do believe we are a top tier performer, albeit a smaller company, and can contend with our well results. We believe our well results are justified the additional cost required. I'm trying to figure out the best way to go through this because I can't control the mouse. We've talked about the 8 wells. These include the Marley pads and the Bonzo pads that are in 1728, which is about 3 or 4 townships to the west of the area in question. So we're an experienced operator in the play, and we have a fairly active program. We are not running a rig currently, but we have been drilling approximately 12 wells a year for the last 3 years.
And turning to your paragraphs 9 through 17, here you talk about the reasonableness of Longfellow's estimated well costs. Can you hit the high points for us here?
Sure. Longfellow, our well costs are associated with our development strategy, and everybody's costs are slightly different of what's in the capitalized portion of an AFE and what's in the operating cost portion of the AFE. Longfellow believes in capitalizing our submersible pumps and other equipment, which increases some of the intangible costs associated with completions, as well as the larger fracs, which are on or about 50% larger than the majority of our offset operators. We drill majority 1 mile laterals, as is common in the play. About 98% of the horizontal wells drilled in the Yeso have been 1 mile laterals. We were the first operator to drill 2 mile laterals, and we have some extended 1.5 mile laterals as well. And we use those where we can achieve those benefits. But the land fabric and the existing drainage associated with a long time vertical development across the play really limits those opportunities to specific areas. So where it's possible to drill more than 1 mile, we do drill more than 1 mile. The drilling costs for these wells are approximately $1.8 million, and the completion costs, including facilities and pipeline, are about $3.5 million when developed as a pad. We could probably move to the next point. So in the proposal, proposals and these things take quite a long time between proposing wells, poolings associated, and then development opportunities. But at the time of the proposals, these wells were estimated to cost $6.1 million per well for what was planned as an 8-well development prior to the knowledge that there was a leasehold expiration issue. Drilling 8 wells at a time requires a significant amount of time. These wells do drill fairly quickly, we average about 8 or 9 days per horizontal to drill. But if we're going to drill 8 of them back to back, that would be, let's just say for simple math, if they're 10-day wells, that would be an 80-day development of drilling. We do not have time to fully develop the unit on an 8-well development program and satisfy the expirations of the leases. So our original proposal of the 6.1 million per well was amended in conversations with XTO, excuse me, to include a 1-well phase 1 development and a follow-on 7-well infill development program. The 1 well obviously is burdened by some costs that are ultimately going to be shared across all 8 wells. For example, the surface location, if you need to build the surface, if you're going to drill 1 well or you're going to drill 8, you need to build the facility to accommodate 1 well or to accommodate 8. And so the individual first well of the unit was revised in conversation with XTO from the 6.1 million to the 7.56 million to accommodate those otherwise shared costs. It is still our intent to, under this pooling order, to drill the first well and to return to the pad after production's commenced and finish out the development. And those additional costs will be shared amongst the other pads.
And are there, I'm showing the slides here that show our development plan and the AFE reconciliation. Is there anything in particular that would be helpful to point out in these 2 slides?
So this is much easier for me to talk towards versus the text. So thank you very much. So with what I've got here on this development plan slide, what I'm showing here is, I mean, Mr. Examiners, you guys saw the acreage position that we hold in the area. There's multiple units, and outside of that map, there's some other units as well that are outside of the expiring acreage in question. So we have significant surface infrastructure that we're planning on building, which the balance of that is a very large produced water recycling and storage facility, as well as surface water transfer lines. We've talked about the desert sagebrush habitat, and so it's our intention to bury permanent transfer lines so we don't have surface lay flat and the risk of spills and things like that could cause harm to the environment. Now, this infrastructure is material in cost. We have, the pit and recycling facilities, approximately 4 million. This distribution system for frac water is approximately 2 million. And all the infill gathering and transportation is another couple of million. And so our plan initially was to have all this ready for, let's just say, the end of this year. For kind of full pad development, and we've had to accelerate our timetable based on the lease expiration. The numbers highlighted in bold, sorry, before you go off that slide, are the numbers that are associated with what XTO is participating in. The numbers that are not highlighted in bold are numbers that Longfellow will be carrying as for development of the area, not specifically just this unit, and are not subject to XTO's participation. And I just noticed one minor error, that the infill 7 remaining units, number 4 on 2027 of 37 million, that should be in bold. That will be something that XTO has the option to participate in under this pooling order, should they participate in development.
Turning now to the next slide, the AFE reconciliation.
So it was argued that our, okay, sorry, here we go. So our initial well estimate from the middle of last year was 6.1 million per well, about approximately 1.8 million of that being associated with drilling, and about 3.5 million of that associated with completions, and another 700,000 per well with the well site facility production facilities. When we've gone to a single well program, there's some costs that have obviously been aggregated in, and I've already mentioned the surface facility or the surface pad for drilling and production facilities, as well as the production facilities themselves. And the other thing that has changed is that most of the gas production in this play, and in really the county in general, is handled by midstream companies. These midstream companies are notoriously late and So with the risk of development timing and our inability or our internal requirement to not flare and produce waste through flaring, we took the option to build the pipeline for gas sales for the midstream company, and they're going to credit us back that pipeline capital because they acknowledge that we can do it faster than they can do it. And so we'll essentially not have to pay gas processing until we recover those costs. But it was a way for us to expedite the drilling of this unit. So that's really how we walk from the 6 million to the 7.5. And I've itemized some of the main variance points. One of the AFEs had contingency costs in it, the other one didn't. So I've kind of reconciled that out. Contingencies are just a 5% kind of fudge factor that a lot of AFEs have for unplanned or unexpected costs. There's an expedited business lease that we're hoping not to need, but we have business lease applications in process that were put in, I believe, in October. And so we're expecting them any day now, but if we do not receive them in time to develop, we'll have to pay an expediting fee. There's a BLM process, or there's a process, I shouldn't say BLM, because I think it's through the realty group, which I'm not sure how that rolls, which division that rolls into. That's an incremental cost. And then as we sort of share costs around how things divide up, really the major variances outside of those two are the gas pipeline of 900,000, the facility that the same first well will bear, but then will ultimately be reallocated to the follow-on wells. And then those are the major drivers between the two numbers.
Turning to your next exhibit, drilling permits, what is the significance of this slide?
So this is the unit in question that we're developing. The yellow lands are the Longfellow 100% YESO rights lands. The blank lands are the XTO lands in question. We have 8 permits in process that were filed. I had it written down. I apologize, but that are filed and pending approval. We expect those really any day now, and we have been working with the BLM on those permits because that unit that we're talking about was water flood, and so that water flood, there were some requirements that they requested for casing and cementing adjustments to protect production casing from the water flood. So we've accommodated the BLM's request on those casing designs, and we're expecting those back. So we do have drilling permits for the full development. We are planning the single well here initially, and once that major infrastructure we're talking about is in place and we've satisfied production from the unit, we'll put that infrastructure in place and we'll finish out the development of this unit.
Turning to your next slide, development efficiency. This is exhibit C5.
So I know, I'm not a lawyer, I'm an engineer, and people talk about waste and prevention and correlative rights. So the YESO was historically developed vertically. I mean, this play has been active for approximately 100 years. And so a lot of the initial development was vertical development. But if we take vertical development, offset a unit, an undepleted unit that's immediately adjacent to it, this is from our local hills development, which is a couple townships to the west. You can see that in a vertical well development, now we couldn't get the acreage, we couldn't get a 320 acre and a 320 fully depleted side by side. So I had to gross up some numbers here, but you can kind of see that the vertical development on 160 acre depletion produced 700,000 barrels of oil, which for a 60 million barrels of oil per section recovered just under 5% recovery of the oil in place. In the immediate adjacent horizontal developed unit, which is also 60 million barrels per section. Obviously, they're adjacent units here. We are estimating to recover about 4.5 million barrels, which constitutes about 15% recovery factor of the original oil in place. So all this to say that horizontal development has far superior efficiency and recoveries, particularly in the Blindberry, but also in the Paddock, because the Blindberry is much tighter, much lower porosity. So the vertical development was not bad, let's just say, for the Paddock, but it's totally inappropriate in the Blindberry for for recovery purposes. So horizontal development, really the punchline is far more effective at recovering hydrocarbons than vertical development. And as I'll point out, the development of that Marley horizontal unit, spacing, landing zones, is analogous to what we're proposing in the Van Halen unit.
Turning
So
to
all
your
three
next,
benches, stacked laterals.
turning now to your exhibit C6 regarding surface use and waste.
So this is an interesting challenge. One of the questions that we initially asked ourselves when we were looking at this area is, well, why haven't anybody else drilled here? And the simple answer is there's sand dunes in this area, and the sand dunes create habitat for desert sagebrush lizards, and the environmental constraints around getting access to surface are very challenging. So our initial pads were actually a little bit to the east, much closer to the section boundary of the west side of the Van Halen unit. And we partner with a group called CHEM, which is a partner of the BLMs. That's a consortium for environmental protection. And so we work very closely with the CHEM group to identify surface locations that are viable and work with the BLM to get them approved. So in this area, we had to back those pads up because of identified habitat in that area. We have now, if we think about a 40-acre development, or 10-acre development is the typical vertical spacing, a 320-acre unit would require something like 32 vertical wells to deplete. Now, you can drill the exact same subsurface acreage with 2 horizontal pads. And so if you run the math on the acreage size of a horizontal pad, on the high side is about 6 acres. And a vertical pad on the high side is about 2 acres. But if you multiply that by the number of pads required, you get to about a 500% increase in surface use of vertical development versus horizontal development. So in our view, horizontal development is the more efficient method from a surface use, and vertical development produces surface waste.
Turning now to exhibit C7, surface access environmental constraints. You talked about this a little bit, but does this slide provide some further insight?
So the image that you're seeing is from an environmental survey we conducted about 2 years ago, where we sent environmentalists into the field to identify potential viable surface locations and try to really work out where the arch sites were, where this desert sagebrush habitat may be, so we could work on pad development. As you can see, there was three categories. There was undetermined delineated habitat, kind of possible and absolute kind of high risk DSL habitat. And as you can see from the Van Halen unit, the majority of the unit is in possible DSL habitat. We've updated this a few times, and so it's quite challenging to get surfaces. Now you can do it, but it takes a lot of time. It takes a lot of effort and a lot of negotiation between us, the CHEM group, and the BLM. So when with the prevalence of the sagebrush lizards there, we've come up with locations that are viable that the BLM has approved. We've passed all our on-sites for these locations, and I'd say the surface locations are imminently pending.
Turning now to your final slide, economic impact of delaying development, exhibit C8. What's important here?
So this I thought was a useful, maybe you scroll down just a little bit more. I think this is a useful tool to understand what we're trying to manage. And it's not only the fact that we want to hold the acreage, we want to open the runway for development. I mean, really, in my engineering perspective, the force pooling process is really to allow for development to occur and not be impeded. So we're sitting here with a situation where this unit that's been holding this acreage is in bankruptcy. If we do not establish production by July, or on or before July, I should say, we're going to look at, there's a multi-year, and it was estimated a 3-year process for bankruptcy to proceed. If I take the forecasted production and associated cash flows of our current development plan, and I delay that by 3 years, there's a negative economic impact. I wrote this somewhere, and there's about a $3 million loss in $3.8 million loss in total royalties to the state just from that delay on a discounted basis. It's 2 million gross, 4 million discounted. There's a $1 million loss in production and tax revenue on a PV0, so undiscounted basis, and about a 2 million discounted. And there's a $3 million, if you add those together, you're looking at a $3 million undiscounted loss of royalty or a $5.8 million discounted loss. So delaying the operations here through impeding of development is a material loss of revenue to the state. Well, actually, sorry, to the BLM here. And well, there's some of these go to the state. Sorry, production tax goes to the state. Royalties go to the BLM.
Before we leave your direct testimony, I'd like to go back to your slide, PDF 105. I was a little bit late in jumping on the slides here, and make sure there's nothing else here that is important for you to note for the hearing examiners. This is your exhibit C1 with respect to Longfellow's well performance that you talked about earlier.
The only thing I'll say about this is that the Elvis pad, so this is the top 50 wells by reserves per lateral foot achieved. The Elvis was drilled before the Bonzos. The Bonzos were drilled before the Marleys. As we continue our development, as we continue our evolutions of our completion design and technological applications, we keep on moving up the curve of better and better and better wells. So in the argument that we're not a prudent operator, this I think is important testimony to show that not only are we a prudent operator when you look at us versus everybody else in Eddy County on all formations, we are continuously getting better and drilling and producing better wells, with our Marley wells being in the top 5. Some of our Marley wells being in the top 5 producers in the whole county.
Thank you. Let's turn now to your rebuttal. Yes.
You're over the 15-minute mark. So how much more time do you think you need?
Maybe 10 minutes for our rebuttal testimony.
Okay, go ahead.
I could bring him back if you like. Okay.
Go ahead, Ms. Sheen. All
righty. So we're turning now back to Ms. McKee's testimony, and that is PDF page. 2, I believe. And here we are coming back to the rig availability, paragraph 10. But I believe Mr. Mitchell has some information about rig availability for Longfellow. So here in paragraph 10, Mr. Mitchell, Ms. McKee represents, it does not appear that Longfellow has any active rigs in New Mexico. Can you, do you have some rebuttal to that testimony?
So while it's true Longfellow does not have any active rigs operating today in New Mexico, we have active negotiations with 10 drilling contractors today. We have 3 drilling contractors that have rigs that we can utilize for these wells that are in question. The companies are Savannah Drilling, Akita Drilling, and Lasso Drilling that have all indicated they have rig availability, and we are working and negotiating actively with each of them. And really, it's going to come down to ultimately price, who we select. They're companies we've worked with in the past. In addition to those 3, we've talked to 7 additional companies that we'll continue talking to, but those are the 3 that we're currently looking to drill these wells.
Turning to paragraph 24, and I believe this is PDF page 6. Here, Ms. McKee testifies about the estimated cost of Longfellow's AFEs. What is your rebuttal to this testimony?
I mean, in the end, we're not in business to spend money. We're in business to produce economic reserves, and we don't spend more money because we think spending money is better than spending less money. We spend more money because we are in the business of making better wells, and that really goes to my initial testimony that there is some of the things that happen are allocations. For example, we do capitalize our ESP equipment, which is about $250,000 capital investment that the operators that were used in the direct testimony from XTO that we're participating in some of their wells. They expense them. And there's pros and cons to each, and everybody's accountants are going to come up with a different argument. And that's every company's discretion. I'm not going to argue one way is superior than the other. That's just our methodology of development and accounting. That being said, we believe that on a cost per recovered barrel of oil, we are as competitive or more competitive than anybody else in this play.
Turning now to Mr. Brown's testimony, and I'm going to share again. Here we're back at his paragraph 7A and 7B, and I believe you're going to testify about his representations in the second sentence, I believe, and correct me if I'm wrong, but whatever parts of this testimony relate to engineering.
Sure. So well spacing is challenging, and figuring it out takes not only a bunch of smart people running numbers, but a bunch of physical tests in the field where you test various spacing and you understand what you're doing. We've run extensive tracer surveys on all of our development units to understand wellbore interference and really dial in our understanding of spacing, not only within an individual landing zone, but also between landing zones, so that we know the kind of interference that you want. You don't want your wells to be too far apart and have undrained oil between the stimulated rock volumes, and you don't want them too close together and essentially have redundant and overcapitalized completion costs. We have what we believe is the optimal spacing for this reservoir, and we feel strongly that the spacing we have is warranted in this play. With respect to the 2,000 foot of unproductive lateral, I think we've addressed that several times with the desert sagebrush lizard habitat. We did have our initial pad locations attempted to be closer to the unit line, and really it wasn't the BLM, but it was the Chem Group who's in a BLM. I don't want to call them an affiliate, but a partner who advised us to move the pads back, and again, trying to be a good steward and trying to work with the other regulatory agencies, we agreed.
And then in the second sentence of paragraph 7B here, he talks about anti-collision drilling risks. Do you have a response to that?
I mean, anti-collision is a known quantity. You know, we have engineers who build anti-collision models and make sure that we have appropriate spacing between horizontals and between verticals and horizontals as we go. And that's not just between other wells in the area, but it's even between your own sometimes when you're back building and doing other things. This is something that every company does, including XTO, routinely, and is not a material risk to development.
And turning now to paragraph 8, I believe one of our rebuttal exhibits might be in response to paragraph 8, which addresses estimated well cost. Am I remembering correctly? Should we look to your?
Yeah, so I provided a rebuttal slide on the Aussie development. And I think this is actually kind of useful also when we talk about anti-collision, because you can see circled in red there a bunch of vertical producers in the Yeso formation. So these were the first 2 mile laterals drilled in the Yeso play that were operated. They were the first 2 mile laterals in the Yeso play that we drilled, but that anybody drilled. And there was vertical wells in the middle of the section that we drilled past. So in the pre-drill assumptions going in there, I mean, look, engineers, we make assumptions, and because there's a saying, it's dark down there. You don't know what you're going to get. So we assumed that the rock in that circled area was going to be depleted. And as such, we did not capitalize the completion of the entire lateral. that's a 2-mile lateral. So in each mile, we have about 25 stages of completion that we pump. And so we capitalized 75% of that 2-mile lateral as completed lateral because with the expectation of drainage. But again, that's an assumption. So as we executed the fracs, we executed these pump-in procedures where we could test reservoir pressure physically through the pressure that if you pump into a depleted reservoir, the pumping pressure that you have is very low. If you pump into an energized reservoir, the pumping pressure is very high. As we were completing this well, we started from the east towards the west, and we got to those zones where we were expecting depletion. We executed these pump-in tests. We did not experience depletion. Therefore, it was an economically justifiable decision to complete those stages. And so while the AFE did not represent an estimate, the AFE was for 37, I believe, completed stages, and the actuals were for 50 completed stages per well, which was the balance of the cost change between the AFE estimate and the actual.
Turning to your next.
Yeah, go ahead.
Turning to your next page of this rebuttal exhibit 2.
So you can see the proposed AFE and the actual cost. Now there were some problems. This was executed in the dead of winter, in the middle of an ice storm. So we had a bunch of freezing issues on the front end, which led to some increased drilling costs. We also had some unexpected, and the current explanation is a shallow nitrogen pocket, which we drilled into, which caused essentially a pressure control issue, which we had to essentially evacuate the gases before we could continue drilling. So there was some cost overruns on the drilling associated with that for both wells, but the majority of the cost variance was associated with two things. One, which I've already discussed, which is 37 stages of completion to 50 stages. And the second one was in the preliminary AFE plan, we were going to have these two wells produced to a secondary, another pad where we had an existing production facility constructed. And unfortunately, in our work with the BLM, excuse me, with the state, this was a couple of years ago, 18 months ago, maybe, commingling was much more stringent. And so they didn't want to let us to commingle these two production units. And so we were forced to build a more expensive battery on this location versus commingling to the other pad. Since that time, actually, and in part, I hope, because of some of the arguments we made, the state has amended their commingling restrictions and now enabled operators to do exactly what we proposed. So these costs can be captured in the future. Cost savings can be captured in the future.
And finally, with respect to Mr. Brown's testimony in paragraph 9, and let's see if I can show all of paragraph 9 here. He's talking about the capital efficiency of wells that are 1 mile versus longer wells. Do you have any additional testimony in rebuttal to this statement by Mr. Brown?
Generally speaking, I don't disagree that there are benefits to longer lateral drilling. We are in the YESA play the only operator that's really pushing longer laterals to date. And so I don't disagree with the assertion. That being said, outside of the longer laterals we've drilled, there's very few, probably less than 5 longer than 1 mile laterals out of the approximately 500 horizontal wells that have been in the play. 1 mile laterals are extremely economic and are proven to recover hydrocarbons at a high recovery factor and positive and economically very justifiable. We do not own interest in the adjacent section, and if we did, we certainly would have proposed longer laterals.
Ms. Shaheen, would you wrap it up? You're past the 10 minutes.
Yes, I believe that is it. I would just ask Mr. Mitchell whether he has anything additional that I forgot to ask him about.
I think you hit it. Thank you very much.
Okay, Ms. McLean.
Yes, thank you. Let me just go back to, okay.
There was actually, Miss Shaheen, I just saw one point about the 158-foot first take point competing proposal that was in Exhibit A8 from
yeah, let's talk about
XTO's
that.
rebuttal.
Well, that exhibit is not yet admitted into the record, so you'll have to
Okay.
come back to testify about that.
I'm free.
Thank you, Mr. Mitchell.
Thank you.
All right, Mr. Mitchell, hello. You've identified in your testimony the Marley and Bonzo wells as analogous to the Van Halen wells. Is that correct?
That's correct.
And these are Longfellow's closest Yeso wells, correct?
They're not our closest. We have closer wells, but they're analog wells, yes.
What makes these analog wells as opposed to the ones that are closer? If you could explain.
Well, I mean, really, they're all analog wells. They were just used because, well, the Marley was used because it was a clean example of an undepleted Yeso section next to a fully drilled vertical section. But we have wells that are probably 8 or 9 miles closer that are also analogs to the reservoir, but not necessarily were perfect for that example.
And not as high producers as the Marley and the Bonzo wells.
We have not, when I was doing the analysis, the quantum of production wasn't really a criteria. It was just looking for undepleted horizontal development like the Van Halen and completely vertically developed like the adjacent. I was just looking for an example that had that. And so a lot of our units like the Aussie that I showed you, which is closer, but it has vertical depletion right in the center of it, wasn't a great example because of the two depletion techniques happening at the same time.
Okay. And the Marley unit area, that's in the south half of section 31 and southwest quarter of section 32, township 17 south, range 28 east, correct?
I believe so, yes. I don't have a map in front of me, I'm sorry. But yes, it's 1728.
I will share a map with you.
South corner of 1728.
I'm going to show you what has been marked as XTO's Exhibit B5.
Okay.
Up here. All right. Do you see this map or Exhibit B5?
Yes.
Okay, great. And so the Bonzo and Marley wells that you've identified as the analogs, they are about 22 miles southwest of the Van Halen wells, correct?
Correct.
And the Marley unit or the Marley wells, you say at paragraph 23 of your testimony is a 6-well stacked horizontal development spaced at 6 wells per section. Is that correct?
So no, there are more than 6 wells in the Marley section.
All right, let me show you. And that's your rebuttal exhibit. Your rebuttal. Okay, here's your. Let me go to your testimony. It's page 98. Sorry, I'm trying to. All right, so your paragraph 23. You say here the horizontal development, Longfellow 6-well stacked horizontal development of the south half of section 31 Marley CD unit with paddock space at 6 wells per section and the upper Blindbury at 4 wells per section and lower Blindbury at 2 wells per section.
Yes, yeah. So sorry. I thought I heard you say there was 6 wells per section in that unit, but there's 6 wells in the paddock. I believe it's 5 wells in the upper Blindbury and 2 wells in the lower Blindbury. So there's 11 wells per section, not 6, as what I thought your question was.
The 6 well stacked horizontal development. Is that correct? Am I reading that correctly?
Yeah, I think the only thing you maybe misunderstood is that's for the half section of section 31, 6.5 section.
6.5 section. Okay, got it. Not the entire section 31.
Yeah.
Okay. And then so how many wells in that section would there be then total?
Total in that section drilled today are 11. There's
Okay.
2 undeveloped lower Blindberry remaining to develop, and there's 1 undeveloped upper Blindberry to be developed.
Okay. So then at 8 proposed wells, that would be 16 wells per section for the Van Halen development. Is that correct?
That's correct, yeah.
And that's denser spacing than these established Marley wells. Is that correct?
That's true to a point. This Marley pad, so in this area where the Marley pad is, there was no lower Blindberry development in the area. So this Marley pad was the first lower Blindberry horizontal development in the area. So we were at the time of development here testing the concept of oil in place in the lower Blindberry. It's very, very challenging to determine from logs how much oil is in place because of just the nature of the reservoir. It's very tight. It's really hard to get accurate volumetric calculations in the Blindberry in total. And so in the Marley section, we drilled 2 lower Blindberries as test wells, which are actually, one of them is one of the best wells in the unit. And so this was the initial kind of, I guess, proving up of the lower Blindberry in the Loco Hills project area.
And when were those drilled?
I want to say the end of 24.
And since then you haven't proposed any additional wells in this Marley unit?
No, we have not.
So at this point, it's still 11 wells per section. Is that correct?
Yes.
Okay. And again, the Van Halen wells are going to be 16 wells per section, correct?
Well, just the way the spacing works, the one in 2 units, one of the units will have 1 or 2 more wells than the unit to the north, just because of the way the spacing works. We don't do it off of
are just for the south half.
Yeah. The reason being, the way the standoffs work in New Mexico, you're allowed 330 feet from the line. And so 2 wells, on the same bench across a section line or a half section line of a different unit are a little too close. So if you have 16 in the south unit, you might have 14 in the north unit.
Okay.
Sorry,
and
on a wells per section basis. That was confusing the way I said that.
and at paragraph 7 of your affidavit, let's go to that. This is on page 92 of the PDF. You state that Longfellow's completion designs utilize the highest fluid loading simulation in the play, which results in a higher completion cost per well, correct?
Yes.
And that the results from other completed wells show that the higher cost delivers superior well economics over the life of the well, correct?
Correct.
And have you provided any of these results from other completed wells to show this superior well economics?
Well, I provided the publicly available data from Enervis, but what I would argue, and correct me if I'm wrong, Mr. Examiner, but that would be something I would think would be kind of a competitive advantage, proprietary information.
Well, I'm asking the question I'm asking you, and this is not directed to the hearing examiner, and you can't ask him for help.
I apologize.
Can't be your phone a friend. The question I'm asking is, have you actually provided as evidence the results from other completed wells that show the superior well economics over the life of the well?
No,
Thank you.
I've only
Uh,
provided the total reserve recovery per lateral foot.
Right. So you have not provided any results from other completed wells to show that Longfellow's higher fluid loading delivers superior well economics over the life of the well. Is that correct?
I have provided results, but I have not provided economics.
Okay. And can you please direct me to the exhibit, your exhibit that you've introduced as evidence that shows results from other completed wells show that these higher costs deliver superior well performance over the life of the well?
No, I said I have provided results, which was that top 50 EUR per lateral foot, but I have not provided economics, which would be, I think, to answer your question, over the life of the well, superior economics. That portion of the question I have not provided.
Great. So that portion of paragraph